Good morning and welcome to the District of Columbia Court of Appeals. We have three cases on the calendar today. The first case is 23 CV 700, Michael Patrick Murray et al. Versus Motorola Inc. et al. Counsel, whenever you're ready. If you could introduce yourself for the record and let us know how much time you'd like for rebuttal.
Good morning, Your Honors. Jeffrey Morganroth on behalf of the plaintiffs' appellants. I'd like to reserve 2 minutes for rebuttal. After 5 of plaintiffs' general causation experts passed Friday, this court changed the expert admissibility standard to Dauber Rule 702, and 3 years having passed, remanded the cases, noting that plaintiffs would receive protections on remand, and I quote, in order to prevent prejudice and unfairness to plaintiffs. But at every turn after remand, the Superior Court's orders cause severe prejudice and unfairness to plaintiffs. There are 9 separate orders that were based on clear mistakes of law and fact, and they cause severe prejudice, including the exclusion of all of plaintiffs' experts and the dismissal of the 13 consolidated cases. I'd like to start with focusing on the Superior Court's erroneous exclusion of the plaintiffs' experts based on their gutted reports and opinions. Plaintiffs' general causation experts were not hired guns. They were scientists, well-renowned scientists, world-renowned scientists, who have devoted, for the most part, their entire scientific careers to studying the radiation that's emitted from cell phones. And this is irrespective and unrelated to their serving as experts in these cases. I'd like to go through each expert. I may not have enough time, but I'll start with Dr. Michael Kunde. So Dr. Michael Kunde was excluded, and Judge Irving noted that Judge Josie Herring had struck major portions of Dr. Kunde's opinion that pertained to Bradford Hill analysis, because Dr. Kunde did not include such opinions in his initial expert report. Judge Irving then erroneously excluded Dr. Kunde. He concluded that Dr. Kunde's opinion in his supplemental report is not supported when considering the Bradford Hill viewpoints, which were stricken that analysis by Judge Josie Herring. Now, Judge Josie Herring's rulings were based on a mistake.
I mean, just to jump in, right, and this is very complicated.
Yes.
I mean, we have to start back with Judge Weisberg saying post-remand, this is what's going to happen. You can put in new studies post-2013. You cannot put in pre-2013 studies, right? And that was sort of the basic. So any new studies that you want to put in, you can put in new studies. You can't put in new experts, right? And by implication, you can't expand what the experts were going to say unless you can tie it to the change in the standard from Fry to Daubert. And it seems like what happened before Judge Josie Herring, former Chief Judge Josie Herring, is that justification was not made. When the expert reports were submitted, Motorola and others moved to strike because the plaintiffs didn't satisfy the directives of the court to say, why are you putting in these new studies? Why are you changing the experts' opinions? And she goes through in her order and says, you just haven't complied with our order. So I'm striking this.
Your Honor, with all due respect, Judge Josie Herring's ruling was based on a mistake of fact and law. And let me explain. Here's the mistake of fact. She construed Judge Burgess's 2011 case management order as requiring a complete opinion of all of the experts, a complete statement of all of the experts' opinions without regard to an evidentiary standard. Now, that's not correct. What Judge Burgess
I'm
intended.
not sure why we're going back to Judge Burgess. I mean, Judge Burgess signed off on the bifurcation,
But
right? That was at plaintiff's request to bifurcate. And the defendants didn't want to bifurcate. They said, let's do this all now.
Well-
And so then it was Judge Weisberg post remand that said, okay, here we are. We are in the bifurcated world where we're just looking at general causation. And here's what we're going to do. We already have been litigating this case. It's now, 2017. And this case has been
Right.
pending in some form or fashion since 2001.
Correct.
So we are going to allow you to supplement in a way that is responsive to the Court of Appeals' decision that changes the standard. But we're not going to let you sort of reshape or refashion your full case. So to the extent that the change in standard meant that there was new evidence for you to present, you were free to do so as long as you justified it under the new standard. And what Josie Herring said, Chief Judge Josie Herring said was, you haven't justified it. Like maybe it is justified, maybe it isn't, but you haven't explained to me, like you just haven't followed the letter of my order. That's how I read her order.
Well, her order, with all due respect, was based on mistake of fact in law. And let me explain. And I was trying to explain because you do need to go back to Judge Burgess's case management order. And the reason why is Judge Josie Herring's ruling was based on a construction, an interpretation of, in part, of Judge Burgess's case management order from 2011, which she felt, she construed that order as meaning that all of the experts had to give a complete statement of their opinions without regard to evidentiary standard. But what Judge Burgess made clear was his intent was to limit discovery and the expert analysis to the narrow issues necessary to determine general acceptance under Frye standard only. And I'll quote him. He reiterated this
I
point.
understand.
Can I just finish, please?
I understand that he thought that Frye was the standard, but Judge Weisberg, when he had the case after the remand, said, look, to the extent that the expert testimony changes because of the standard, that's when you can get he's doing a discovery order. You can get discovery as to that, but you can't get discovery on new stuff.
No, that's not what Judge Weisberg said. What Judge Weisberg said was that the plaintiff's experts would have the opportunity to supplement their expert reports with any new studies post 2013. That's what he said.
No, but
He
no, he
also
also,
said-
okay,
he also
maybe you're
said
saying the same thing
that-
I am, yeah.
He also said that the plaintiff's experts could change the way they articulated their opinions to the extent that the new standard, they explained why they would need to change the way they articulated their opinions because of the change in the expert admissibility standard. He did not say that they had to be both.
But how,
It was either one.
well, right, but then that gave your clients the opportunity to do the latter. You didn't have to, but it gave you the opportunity to do the latter. And how did that not cure what you're saying is the flaw in Judge Burgess's initial order?
Well, no, I'm not saying Judge Burgess made an error.
Well, he didn't make an error because Frye was the standard at the time,
Correct.
but what you're saying was prejudicial to your clients
Because-
post Daubert, our post Motorola. How did that not cure that problem?
It would have cured the problem, except for the fact that Judge Josie Herring then struck
Right, because she
300
said that,
studies that were post 2013, 300 studies.
right, but because on the ground, whether she was right or wrong, but on the ground that you didn't satisfy your opportunity to then update the expert reports to account for the adoption of Daubert in 702.
No, Your Honor. What she said was you can't add any studies that are post 2013 unless they directly relate to a statement made in the initial report. And that was an error because her reasoning was Judge Burgess in 2011 said all opinions had to be stated completely in the original reports, irrespective of evidentiary standards. That was wrong. Here's what Judge Burgess said. And he reiterated, it's Appendix 452, and I quote, "While the order I issued did not mention general causation as determined under Fry, it is clear to me from what I said at the hearing that that is the intent of the order and it should be construed that way. Accordingly, Judge Burgess directed the parties to put aside Dauber," that's a quote, "and strictly focus on the Fry-Dias general acceptance standard and specifically the existence," and I quote, "a consensus among the scientific community." So Judge Josie Herring was wrong. Judge Burgess did not require a complete statement of all opinions, irrespective of an evidentiary standard. Now, the second error was an erroneous legal reasoning. Judge
I
Josie
just keep
Herring.
coming back to Judge Burgess's order, post remand, where he says the question before the court on remand has not changed. Do plaintiffs have admissible expert testimony on the general causation issue in these cases? There are only two reasons that question cannot be answered under the new standard on the present record. There may be scientific studies done after the experts submitted their reports for the phase 1 litigation, which may support or undermine the opinions of plaintiffs' experts under the new standard, and the experts should be permitted to supplement their opinions accordingly. And 2, plaintiffs' experts rendered their initial opinions in the Dias-Fry regime, and although their opinions would not change simply because the legal standard for admissibility has changed, it is at least conceivable that some might articulate their opinions differently if they were called upon to address reliability of scientific principles and methods reliably applied to the facts of these cases as required by 702, and not merely the general acceptance of their respective methodologies. And that is why he said, this is how discovery is going to be structured. And it seems like Chief Judge Josie Herring's order follows in that line by saying, and this is how, these are the expert reports that we're going to allow. We're
No.
not going to allow a
Well,
redo.
First of all, that's not what that was Judge Weisberg, not Judge Burgess, I think.
And exactly.
but what Judge Weisberg said-
Post remand.
He actually said,
I
we
just
asked for-
read to you verbatim.
I
from what he
understand, Your
actually
Honor.
said.
he
Okay.
did say that. Judge
That
Josie
was his
Herring didn't
March
let us do
16th
that.
Order on page 3 to 4.
Judge Josie Herring didn't let the plaintiffs do that. She struck 300 studies that were post 2013. Judge Weisberg, if you read his specific language,
I
he
just did read.
He
the
permitted
specific
the
language.
plaintiffs,
Okay.
he permitted the plaintiffs to supplement their expert reports with any studies that were post 2013. There was no qualification to that. He also, in clarification, I can get to the specific quote, but there is clarification on the record because I actually asked him, what if it changes their opinion? And his answer to that question was.
What page did you ask him that?
I'll look it up. His answer was, they
Can
can,
you give
if
me a
it,
page,
if
please?
they learn something new, they can, and it changed their opinion.
I'm sorry, can you give me a page, please?
Yes, Your Honor, I'll have to
Thank
look
you.
it up. I don't have it handy, Your Honor. I will find it before the end
Okay.
of this hearing.
It's hard to read along if I don't have a page, so.
Okay, but I'll quote him, I'll paraphrase him. Judge Weisberg said that the plaintiff's experts, if they could change their opinions, if they said that they learned something now that they didn't know before, and now they could say something different, whether it was a change they could no longer say or whatever it may be, they could do that. And Judge Josie Herring didn't let them actually, any of the plaintiff's experts, change their opinions at all or changed the articulation of their opinions based on the new standard. I did want to explain why there was erroneous legal reasoning there too, Your Honor, because Judge Josie Herring, she believed that there was no right to supplement expert reports under Rule 26A2B. She said it didn't govern because the court had set deadlines for expert disclosures. And This court has held that a trial court abuses its discretion by failing to modify a pretrial order to allow for supplemental expert reports, whereas here there'd be no prejudice and change circumstances, including the availability of new information. I'll cite to Daniels versus Beeks as the leading case in that
The
area.
chief said that the rule didn't apply because there was a pre-existing order that she's thought controlled, right? And the
Correct,
text of the rule says that you can supplement unless there's a court order to the contrary, right? Something like that.
Well,
I'm
actually,
paraphrasing.
I'm citing the Daniels versus Beeks case that says an abuse of discretion not to change that pretrial order to allow supplemental expert reports if there's no prejudice and there's a change of circumstances. That's exactly what
If
happened
there's
here.
a change of circumstances, and implicitly she was finding there's no change in circumstances, we've discussed this, you know, starting with Judge Weisberg's order, we've discussed how this is gonna go. And there were, you know, just multiple
You're,
occasions where the plaintiffs were saying, we want to go beyond these parameters, and the courts kept saying, no, we're sticking to this plan.
Your Honor, that's holding the plaintiffs to the science from 2013. The change of
It's
circumstances.
not holding the plaintiffs to the science from 2013. The plaintiffs were asked, show us why the new science should come in under the new standard, and you can do it. And that's all you have to do.
That's not what Judge Weisberg said. He said we could do one or two, either, it was an either or both proposition. You can either, any new science from 2013 that would be relevant to their opinions, that they thought was relevant to their ultimate opinions, could be used to supplement. In addition, because the standard changed, it would change the way they articulated their opinion.
I mean,
They could
I
do that.
just read you from the March order where he says, new scientific studies which may support or undermine the opinions under the new standard. So you just have to show how it applies under the new, how it's new
It
under the
wasn't
new
a
standard.
Your Honor, it was not a conjunctive. It was either or. It was, Your Honor, there was a change of circumstance. There was 8 years that had passed. At that point, there had been 4 years. There was an explosion of the scientific studies, peer-reviewed published scientific studies.
Right, and you got in, I don't know, some number of those new studies without objection.
There were 300 that were stricken. 300
Right,
studies.
how many new studies did you present?
There were over 400 at the time. There was probably 100 that were allowed, but 300 were stricken. There were whole opinions, new opinions that were formed based on the new scientific studies that were stricken. According to Daniels versus Beeks, it was abuse of discretion to not allow the plaintiffs' experts to amend or supplement their expert reports to account for the new science. It held them to the science in 2013. This should be a search for the truth.
But
Your Honor.
I mean, certainly you're not arguing that Chief Judge Josie Herring it would have been abuse of discretion for her not to allow all 400 of those new studies in, right?
Yes.
She's still conducting her gatekeeping function at that stage of the litigation, right?
Right, it was an abuse of discretion because irrespective of the change of the standard, there had been so much time that had passed. Now there was an explosion of scientific studies, peer-reviewed public scientific studies, that the plaintiff's experts should have had the right to supplement the reports regardless. And this is an unusual case because there was a long time lapse, but now we came back from the Court of Appeals with a new standard, which measured reliability as opposed to measuring general acceptance of methodology only. So the plaintiff's experts should have had the right to explain and address the reliability standard. Actually, Judge Josie Herring did not let them do that. She struck every single attempt to address the reliability standard, including Dr. Panagopoulos. He was allowed back in by Judge Weisberg because he was the only one that was struck on the Frye dais on the basis that his exposure methodology was not widely accepted. So it was not generally accepted, that portion of his methodology. But under Dauber, a technique can be reliable even though it's not generally accepted. He tried to explain why it was reliable, and Judge Josie Herring struck that portion of his opinion. He had studies there were from post 2013 peer review studies that show that his methodology was reliable and corroborated his results. It was all stricken. The same thing happened with the incidence report, incident trends and data. Dr. Liboff was stricken or excluded first by Josie hearing portions of his opinion, but by Judge Irving on the basis, in part, that he couldn't account for the incidence data and trends. But he did account for that. It was stricken by Judge Josie hearing on the basis that it wasn't part of his original report. But there had been 6 new studies that he had cited, which were post 2013. Those were not considered at all. In addition, Dr. Liboff and Dr. Belayev had portions of their opinions stricken that dealt with incidence trends and data. That's because, again, Josie Hearing said it wasn't part of their initial reports, but it was based on new science, new scientific studies that came out when their initial reports, after their initial reports, 4 years later. In addition, we tried to add, the plaintiffs tried to add Dr. Portier. Dr. Portier formed opinions based on the new science in March 21st of 2021. One of his opinions was on incidence trends and data. That was stricken. So Judge Irving is looking at a record without sufficient information, and he is not considering studies, scientific studies and opinions that were post 2013. The effect of all this was to hold the plaintiffs to the science in 2013. There's a Ninth Circuit Court of Appeals case, Pomona, that is directly on point and instructive. Same thing happened there. It was determined to be an abuse of discretion because the court did not allow, after a 3-year appeal period, the plaintiff's experts to supplement the reports based on the new science. It was a forensic examination, the new science. And therefore, they were held to the science during three years prior.
Counsel, I think we have your argument and you're over time, so I'm going to let you sit down. I would like that record site when you come back on rebuttal, and we'll
Thank you,
hear
Ron.
from your opposing counsel. Thanks.
May it please the court, Terry D. representing the Motorola defendants and arguing on behalf of all defendants this morning.
So,
Your Honor, Your
Counsel,
Honors, yes.
Appellant argues that they just simply were not allowed to present their case, that this was all very unfair, that the standard changed for this court's opinion, and then they just weren't able to respond in any sort of meaningful way to the change in the standard and put forward the studies and the experts that were out there to present their case. So what's your response to that?
Well, I think Your Honor hit it directly, the nail right on the head. Judge Weisberg, by the way, who had the Motorola decision noted that Judge Weisberg was learned on the science, that he was an expert on Rule 702. So when this case was remanded back to Judge Weisberg to determine how should this case proceed, there was no one better to evaluate the situation, the change in standard. He was the expert on Rule 702. He had sat through a 4-week
It's
hearing.
sort of an odd thing to say that a trial judge is an expert on evidentiary rules, but yes, he did have the case and he did issue what appears to be a thoughtful order. So do you want to explain to us why that impacts your answer to my question? Or
Yes, so he was able to take into account and exercise his wide discretion in what is the proper way to proceed in this manner. So he did take into account that there was new science, and he allowed the plaintiffs to supplement their reports, their experts' reports, with new science after 2013. And he took into account the fact that the standard may have changed. During the testimony that the exchange he had with Mr. Morgenroth, he was doubtful that experts actually would give an opinion without considering all the evidence and gear it towards a particular standard. But nevertheless, he said the experts should have the opportunity, if they needed to change the change their opinion based on the change of standard, they need to express it and explain it. And then Judge Josie Herring picked up that order once she had the supplemental reports, and she said, here's the process. What I want you to do is identify for me all the post-2016 studies. And all you have to do is tell me where in the prior original reports those studies are being used to supplement. And then she also said, and for your new opinions and for any way you change the way you expressed your opinions, you just need to explain to me why the change in standard required you to do that.
So did she require both of those things as to the full scope of supplementation? Because it seems like that's where your colleague is saying she went wrong. Because you could read Judge Weisberg's order to suggest that the defendants could add new studies and separately explain why or supplement their reports to account for the new Daubert standard. And I think they're arguing that Chief Judge Josie Herring required them to do both of those things instead of one or the other.
Yeah, Chief Judge Josie Herring had a massive amount of material. And in fact, the parties had first fully briefed the issue of the defendant's motion to strike. And then she evaluated that. She said, look, here's how I need the parties to provide me, here are the tools I need to make this evaluation. So for purposes of determining whether the post-2016 studies were submitted to support a prior opinion or to support a new opinion, she just said, there's an easy way for you plaintiffs to prove to me that the 2016, post-2013 studies are actually new science just by tying it back to the old opinions. So that's what she did. She said, send me a chart, put in the post-2013 study, and just identify for me where in the expert's original report this study was used to support that, that point or that opinion. And so that way she was able to measure, was this really being added to support the original opinion, or was this new science trying to be used to support a new opinion? And that went in conjunction with the articulation of why do you need to change the way you express your opinion because of the new standard? Just explain that to me.
They
So
seem to be arguing, but we should have been able to put in new opinions based on new science. I think that's a fair characterization of their argument.
yes, they do take the position they should have been able to give new opinions, but that's what.
What's the answer? Why doesn't that have at least intuitive appeal?
Well, because it was inconsistent with the original case management order, which Judge Burgess entered, and then Judge Weisberg looked at it and said, hey, look.
I mean, Judge Burgess entered his order. What year was that?
2011, right. And,
I don't know that he foresaw, maybe he did. He was a wise man, is a wise man. Maybe he foresaw that it was going to take this many years for this case to move through the District of Columbia courts. But, do you think that foreclosed any other judge from exercising their discretion to say, it's been a long time. The underlying question is, does radiation from cell phones cause these types of cancer? If there's new science out there, these people should be able to present it.
right. And Judge Weisberg recognized that. And then that's why he allowed the experts to supplement their original opinions with the new science, but he wasn't going to allow them.
But did Judge Josie Herring allow that? I think is what Judge
She
Schenker
did.
is asking.
She did. Judge Josie Herring allowed many new.
To the extent that if she's only saying you can only supplement your prior opinion, what if the new science gives rise to sort of a new opinion of, oh, it could, the causation could be this way, but actually, given the new science, there might be a new theory of causation this other way. I'm keeping it very basic because I am not a scientist.
Right. And so Judge Weisberg, it all goes back to Judge Weisberg's decision in 2017 as to how are we going to proceed with this Rule 702 evaluation, given the considerable leeway that he's provided under Kumu Tire and this court's Motorola decision. How are we going to do that? And he said, we're not going to start from square one. The plaintiffs had a fair opportunity to develop their opinions. And he heard a 4-week evidentiary hearing on what those opinions
Right,
were.
but they
And then
developed those opinions based on presumably the evidence in 2001 or 2011. And I don't know that I see in Judge Weisberg's order, but you feel free to point me in the right direction, where he is saying, look, he does say you can't put on new experts, right? We're not, finding new people for you to call as experts. But I don't know that he says the experts that you have can't express new opinions on new science. Does he say that?
yes, he does. He does say in his opinion that the experts cannot, and that's the whole point of they have to express their opinions, the same opinions that they had in.
Where does he say, where do you think he's saying that?
It's in the opinion, Your Honor. I'm having difficulty finding it right now, but he addressed the issue of whether the experts would be able to expand on their opinions. And that was the whole point of the second part of his ruling, that the plaintiffs could revise the way they express their opinions to account for the change in the evidentiary standard, so long as they explain why the change in the evidentiary standard necessitates change in the way they articulate their opinions. So he did allow for them to, they gave general causation opinions in 2011. They were allowed to supplement their reports with new studies and to change the way they express their opinions, so long as they articulated why they needed to do so because of the change in standard. And that was the fair thing to do. The plaintiffs, as counsel said, their view was they had world-renowned scientists. They didn't need any new experts. The methodologies for determining causation hadn't
Well,
changed.
they did want to put on a new expert, but they were not permitted to do so.
Right. They were not permitted to do so after 11 years of the case being gone through the general causation phase one. And we'd already had full supplementation of the expert reports, litigated those expert reports. We'd already had full discovery of the experts. We'd already briefed the Rule 702 exclusion. And we'd already set a hearing for having an evidentiary hearing in front of Judge Irving. And then they wanted to add a new expert, Dr. Portier. But Dr. Portier didn't add anything new. The disciplines, the topics that he wanted to discuss were the same topics that the plaintiff's experts already were discussing. The disciplines that he brought were the same disciplines that plaintiff's experts already had. There's no reason why plaintiff's experts couldn't supplement their opinions with the new science that Dr. Portier claimed to have. And significantly, Dr. Portier, on the most important evidentiary basis for determining causation, the epidemiology, if you look at Dr. Portier's cohort studies and case control studies, the original epidemiology that he relies on, and this is on tables 1 through 7, starting at page 21 of his report, all of that epidemiology is 2015 or earlier. All of it. Now, he does cite, and that's the same epidemiology that Judge Weisberg and all the authoritative bodies worldwide say is biased and unreliable and can't form the basis of a general causation opinion. So while Dr. Portier did cite some meta-analysis of those studies, if the underlying data is unreliable, then the meta-analysis is unreliable. So it doesn't do them any good. There was nothing new with Dr. Portier. And so Judge Irving was well within his wide discretion to enforce the orders of Judge Weisberg and Judge Josie Herring and not allow that expert to come in. So in terms of going back to the Rule 702 decision itself, Judge Irving properly exercised his discretion. And I want to emphasize this point because it cuts through all of these arguments the plaintiffs are making. He properly exercised his gatekeeping authority to exclude plaintiffs' general causation experts in this matter, and the plaintiffs haven't shown that there was an abuse of discretion, nor could they, because plaintiffs can't get around the fundamental problem with their experts' opinions. They lack scientific validity, and therefore they do not have evidentiary reliability because they failed to apply a reliable methodology reliably. So Judge Irving's conclusions are consistent with what Judge Weisberg found in 2014, that the epidemiology that they base their opinions on is unreliable, that they do not and cannot reconcile their causation opinions with the actual brain cancer incidence data. That is, that despite the widespread use of cell phones over the past 35 years, the incidence rates of brain tumors has not risen at all. It stayed flat. Three.
But, I mean, it seems like your colleague's argument, though, has to rest then, if we accept what you're saying with respect to Judge Irving's order on the prior exclusion of 300 so studies by Judge Josie Herring, which by definition Judge Irving didn't have at his disposal because they had already been excluded.
So here's my
I realize
response to
we're
that.
now going back around to the beginning of your argument, but
Right. But Judge Irving excluded the plaintiff's experts for a number of reasons. And one of which is under Rule 702D, that they didn't apply a reliable methodology reliably. So it doesn't matter if they had more science. If they don't apply it reliably, then they don't have an admissible decision. So Judge Irving's Rule 702 determination that these experts were not allowed to be in because they were using flawed methodology and applying that methodology unreliably cuts through all the discovery issues, because that's a fundamental basis for excluding the experts, as opposed to sufficiency of the evidence or one of the other grounds that, one of the other many grounds that Judge Irving used to exclude the experts. So in conclusion, Your Honors, there were three highly esteemed Superior Court judges who managed this complex tort litigation and discovery with transparency and well-reasoned, thoughtful, legally supported rulings. Plaintiffs have totally failed to engage in the Superior Court judge's analysis and satisfy their heavy burden of demonstrating how the court's decisions were clear error and prejudicial. The decision should be affirmed.
Thank you, counsel.
Thank you.
Mr. Morgenroth, we'll give you a few minutes.
Thank you, Your Honor. I'll start with that citation that I have located that you asked me for, Your Honor. It's Appendix 3367, and I'll read the quote by Judge Weisberg, where he was clarifying his ruling on the record. If there's new information they can say, I now know what I didn't know then. And I think that's important to my opinion. It reinforces my opinion or causes me to change one aspect of my opinion that I thought I could say, but I no longer could say. So what Judge Weisberg was explaining is if there were scientific studies that came that gave them, informed their opinion, and it either reinforced it, they could cite that. Or if it changed their opinion, they could do that too. And the problem is that Judge Josie Herring didn't let the plaintiffs do that.
But I mean, she did, because I mean, I don't think that Judge Weisberg's order contemplated your client simply putting in 400 new studies. It required Chief Judge Josie Herring asked you to line that up specifically. I mean, we can't expect trial judges to go through 400 studies and correspond them to the places in the experts' opinions that they now newly support. So she gave you the opportunity to do that yourself.
And we did do that, Your Honor. And what happened was Judge Josie Herring rejected that. We tried that with Dr.
Right, but there's a
Igor
difference
Belayev.
between your argument that that you didn't have that opportunity or that she rejected it out of hand versus her exercising her discretion to determine whether you did it adequately,
Well,
right?
but we should never have had to do that in the first place
Well,
because
that-
under Rule 26A2B, we should have had the opportunity to supplement the expert reports. There would have been no prejudice. And there was a change of circumstances. There was an explosion of scientific research that were peer reviewed. Plus, there was a change of the evidentiary standard.
Right, and but you did have that opportunity. And
Well,
all the trial
no.
judge asked you to do was to line it up to a voluminous.
We shouldn't have had to line it up to anything because there was a change of circumstances. What prejudice would there have been? And I'll concite to Daniels versus Beeks or Weiner versus Neller. Under ordinary circumstances, Weiner versus Neller. That case holds that can supplement an expert report 5 months before trial, as long as there
But we're
has
talking
been
about-
no
we're
prejudice.
talking about the how, not the whether, right? You were permitted to supplement. It's how you were permitted to supplement. I don't know. I mean, I'll go back and look at Weiner. I'll see if it speaks to that. But when you're talking about a case where there are hundreds of new studies, multiple different experts, and a trial judge says, do it this way so we can process the information, then you have to do it that way. And as Judge Schenker said, it seems like the court said you didn't do it adequately. It's not that you,
But
weren't given the opportunity. You didn't do it adequately. It was her determination.
well,
And I'm not sure that I see in your brief where you explain why she's wrong that you didn't do it adequately.
I think the answer to that, Your Honor, is that you didn't have to do it adequately. All you had under Daniels
Well,
versus Beeks,
Heavens
it's,
to Betsy. I mean, this record, we have, I don't know how many volumes of the appendix. And if you didn't give us, a table of contents and, cite these things in a way that we could process them, I would think that that would be problematic and prejudicial. So I have a
Well-
lot of sympathy for the trial judge saying, I have this big case. It's not my only case. And I need you to give me this information in a way that I can consume it and in the way that opposing counsel can consume it. And is that what you're arguing against?
no, Your Honor. What I'm
Okay.
arguing against is the plaintiffs, like every other plaintiff, has a right to supplement expert reports.
Nobody is disputing that.
And
It wasn't
the-
disputed
the-
here.
yes, it is, Your Honor, because the case law says it's an abuse of discretion not to allow there to be an amendment of a pretrial order requiring the disclosure of expert witnesses or prohibiting them from supplementing their opinions. And that's what happened here.
But what comes into a trial court in a situation like this are expert reports, right? Not just the studies. I mean, you can't just throw 400 studies.
Well, they didn't, Your
Right,
Honor.
but-
They supplemented their expert reports. In fact, contrary
I
to
mean, there's
what,
one instance, right, where she asked you to say, how do these supplemental reports supplement your expert report? And you cited some line in some expert report that was a blank line, right?
yes. The
And
problem there, Your
so,
Honor,
and she said, I have no idea, and I've looked at the text around this blank line, and I have no idea how these reports supplement a blank line in an expert report.
Your
I
Honor,
can see her throwing up her hands and saying, I don't have time for this, right? And if you can't explain to me, and if you can't, make sure that you don't have typos in your submission, and you didn't come back and say, oh, I'm so sorry.
Yes, we
It
did,
was a
Your Honor.
blank line. We didn't mean to cite that line.
It-
You came back and said, no, actually, this is how, you know, you had some other excuse. And she said,
It's not
no,
an
I'm
excuse, Your
not,
Honor.
I'm not hearing it.
Your Honor, Judge Josie Herring didn't understand. We had oral argument. I explained it to her. She asked us to show where those studies would fit into the original report. We shouldn't have ever had to do that under Rule
I
26A2B.
hear that you don't think you had that obligation.
But, okay. So I explained to her what we did, and that was Dr. Igor Belayev. He has a very long, detailed, comprehensive expert report. The blank line was to show where each study, and we had it colored, we had it numbered, was to show where each one of these studies would have fit into his original expert report. This wasn't a typo, it wasn't a mistake. She wanted us to show where it fit in. We actually took his actual initial expert report
Right,
from
and she
2013.
looked at that explanation, after the fact explanation, and said, this doesn't add up to me. I'm reading through his report. These studies don't seem to fit into this at all.
They did, Your Honor, and he
Okay,
explained, he testified why she didn't want to accept it. I don't know why she didn't want to accept it. For whatever reason, but she was wrong. That was a clear mistake and error. It showed exactly where all of these studies would have fit in. And we didn't just say, okay, here are 400 new studies. The experts actually supplemented their reports, issued new reports, comprehensive reports, not just saying, oh, here are new studies. In fact, some of the experts testified, and in their reports, they said, based on this new scientific studies, we can form new opinions. Dr. Liboff formed a brand new general causation opinion, which he said, I couldn't say this before. I can now because of the explosion of scientific studies. Dr. Moskowler did the same thing. He had a general causation opinion he issued on the basis of the new studies, only on the basis of the new studies. He said, I couldn't say this before. Dr. Plunkett said the same thing, that the studies weren't robust enough in 2013 for her to issue a general causation opinion, but now she could. And she explained why. These were all stricken because they were new.
But they weren't all stricken. I mean, she allowed in some supplementation.
But these new opinions were stricken based on the new science. And Dr. Portier, he said in his opinion and our motion, he had indicated that he was only able to form a general causation opinion that would be relevant to this case in 2021 based on the new science. He cited 92 new scientific studies that were peer reviewed. And when you put those together with the old scientific studies, he now could form an opinion. And part of that opinion was incidence trends and incidence data, which was stricken, actually not stricken. They wouldn't even allow him to be added. But this was also based on a mistake of fact. And
Do we have an explanation? I mean, as we've discussed, some number of studies did come in without objection. And then 300 some studies were stricken. Do we have some sort of briefing on the prejudice, sort of what the stricken studies would have showed that the studies that were admitted did not show?
Yes, Your Honor. What would it, and we lay this out in our brief, the decision by Judge Irving excluding the plaintiff's experts was based on not having sufficient facts and data.
That's a slightly different, like,
well,
I mean,
he
do
said
we
they didn't have
something to drill down to say, this is what the studies that came in showed, and this is what the studies that were excluded would have added?
No, because it's a little bit of a different argument, Your Honor. The argument is,
I agree, but I wonder if it's something that is necessary. If, you know, if we were to agree with you, the Chief Judge Josie Herring was wrong in some aspects of her ruling, then we have to see if it has any impact.
well, yes, that is because the argument is a little different. Take, for instance, Dr. Kundi. Dr. Kundi, he had a Bradford Hill analysis that he did in his supplemental report to address the reliability portion of the Dauber standard, which was not relevant to Frye-Dias because Frye-Dias was only looking at general acceptance of his methodology. And Judge Burgess said, put aside Dauber and only deal with general acceptance. So he had a Bradford Hill analysis. Judge Josie Herring struck it. She struck it because he didn't have it in his original expert report. Well, he didn't have it in his original expert report because it wasn't relevant to general acceptance of methodology, but it was relevant to whether or not his principles were reliable and he reliably applied it. So he added that. She struck it. Judge Irving then, in part of his exclusion ruling, said, I noticed that major portions of Dr. Kundi's expert report were stricken relating to Bradford Hill analysis. And therefore, he concluded that Dr. Kundi did not satisfy the Bradford Hill viewpoints. Well, he didn't satisfy because he didn't have.
Anything that drills down that tells us that that exclusion harms you because it is not cumulative with all of the other information you have in?
Well, yes, for instance, Dr. Kundi was strict, he was excluded also on the incidence data.
So there's no other incidence data in what you've got in. This was a unique opinion that uniquely harms you that is nowhere else.
Well, yes, because what happened was all the incident data opinions were stricken by Judge Josie Herring. So for instance,
But is this
Dr.
clearly,
Kundi
is
had
this
6
clearly spelled out in your brief is the question, right?
I guess I was trying to clarify it and hopefully expound on it during oral argument. I may not be as clear in there. It lists all the categories that were stricken and gutted, including opinions of theirs. And all of this was not considered by Judge Irving because of the fact that it had been stricken, and he gave deference to Judge Josie Herring. I'd be happy to do a supplemental briefing that would actually lay out exactly what you want, because in answer to Judge Howard's question about incidence data, Dr. Kundi attempted to cite to 6 new studies. Those were all stricken. He also had his own peer-reviewed published article that was stricken on incidence data. And then the only other incidence data that was cited to was Dr. Liboff, who added that to his opinion, and Dr. Belayev, based on the new science that had exploded. Those were stricken by Judge Josie Herring because those were new. They weren't part of the original expert reports. They couldn't be part of the original expert reports because that science didn't exist. And then Dr. Portier, we tried to add him. He had a portion of his expert report on incidence data as well. And that was not allowed, even though there was good cause to add an expert at that period of time, especially under the Tisdale factors. But no one, Judge Irving and Judge Weisberg, did not apply the good Tisdale factor analysis, nor did they determine whether or not there was good cause. There was a mistake of fact. Judge Weisberg felt that Judge Burgess said you could never add an expert after 2013, after the disclosures based on the case management order. That's not correct. Judge Burgess actually acknowledged that you could always add an expert if you had good cause and you asked the court for permission. So we asked the court for permission, but that was rejected. And the reason why it was rejected was on the basis that somehow this would prejudice the defendants by delaying the orderly administration of the trial. There was no trial date. And actually the process that had been set up here was that the plaintiffs would supplement their expert reports. Then the defendants had the opportunity to supplement their counter expert reports. So they would all be analyzed by defendants experts. Then there would be discovery, there would be depositions taken, and there were depositions taken. All of this material was stricken before the defendants even responded with their expert reports and before depositions. So there would have been no prejudice and there's no trial date. This was completely prejudicial and unfair. It should have been able to add experts. There was good cause. There was an explosion of scientific evidence that was not in existence before. There were new experts, had formed new opinions. All of it was stricken. No one was allowed to be added. And the portions of the expert reports that had new opinions, those were stricken.
Counsel, I think we understand your argument.
Okay.
We appreciate your time here today, your opposing counsel as well. And this case will be submitted. Thank you.
Thank you, Your Honor.
The next case on our calendar today is 23 CV 422. MP PPH LLC versus the District of Columbia. My understanding is that we'll have an argument from appellant and then we'll have argument from appellee and then argument from amicus. 2 minutes of time, is that correct? Okay. Counsel, whenever you are ready.
Good morning, Vernon Johnson from Nixon Peabody, representing the appellant MP PPH. I'd like to reserve 3 minutes for rebuttal. May it please the court, MP PPH is before you asking for relief from an order entered in the context of a civil contempt claim arising out of a show cause motion that posed a situation of indirect or constructive alleged civil contempt in the context of a consent order that was negotiated between MP PPH and the district after the start of the case, which was filed originally in July of 2021. That proceeding metastasized eventually into a situation where the contempt ruling went beyond the parameters of civil contempt and was an abuse of discretion that under the Ford versus Chart 1 and the Johnson versus United States standards for viewing an abuse of discretion in this context, reversal likely is called for.
Counsel, I'm sure you were prepared to discuss the 28K letter that we received yesterday from the district notifying us that MP PPH, excuse me, closed the sale for this property at the end of the year. And so the suggestion is perhaps that you all don't have an interest anymore in this litigation. Can you speak to that?
Of course, Judge Easterly, and I'm not sure because we filed something later in the afternoon if our
We received it.
response is before everybody. I'm glad to hear that it is. The issue posed by the notice that the district filed is that the property was sold, the apartment complex was sold on December 31, 2024. This is not a new event. I don't know why this gave rise to something being filed yesterday, the day before oral argument, but I don't read what they're saying as a clear statement of what they think the effect of that is. They sort of suggest we're not sure that the Court of Appeals could provide any financial redress under the circumstances. They're not saying expressly that they believe the appeal is moot.
Well,
I
we agree.
recognize their language is sort of is couched, is qualified, but we have our own interests in only litigating live matters.
Of
And
course.
so, walk me through. I'm not a bankruptcy expert, but my understanding is that this property was sold with the blessing of the bankruptcy court and the creditors. And so why is it that you think that any outcome of this case that would lift the rent abatement, why do you still think you have an ability to challenge that? I guess more pointedly, just having quickly read through the submission, which is lengthy and again, written for people who are more expert in bankruptcy proceedings. I don't see anywhere where it says, as one might expect it to do, look, MP PPH can continue to litigate its appeal of the consent order and recoup any money from any decision by the Court of Appeals that the abatement was improper. And I'm not even sure how that could happen because you would have to recoup money from the tenants. And it seems like the settlement agreement says you can't go after the tenants for any purposes. So those are my kind of pointed questions as to how could you get any relief from this appeal?
And the filings in the bankruptcy court don't reference this appeal specifically. And I think ultimately the determination on whatever rights MP PPH still
Well,
has.
that's curious, right? I mean, it seems very odd in a situation where you have a creditor, you have a group of creditors who are very interested in, this property. And you would not account for any money that would flow back to MP PPH through this appeal if you thought that that was possible. It seems very odd that you would have a bankruptcy proceeding where there could still be a flow of money that was untouched by the bankruptcy proceeding or unblessed by the bankruptcy proceeding that your company could receive.
Well, and there's one instance for certain, as we mentioned in our filing, that is an asset of the bankrupt estate that would be an asset affected by this. And that is the relief that Judge Kravitz awarded was retroactive. And he
I
ordered.
understand that goes directly to my concern that if hypothetically, we were to say Judge Kravitz erred and that the abatement was, the retroactive abatement was improper, then what happens, right? Then you have tenants who didn't pay rent and you would go after them for unpaid rent, except that this settlement agreement says you can't do that. So I just, again, I'm not understanding how you have a continued interest in this litigation in light of what has happened in the bankruptcy court. I'd love for you to just explain to me in concrete terms.
What I was
Right, you
focusing
do.
on, and it's not the only reason, but the one key reason is part of what Judge Kravitz ordered was that if there were residents affected by his order that didn't live at the property anymore, they had to be issued a refund check. And refund checks were issued, but there were a number of tenants that could not be located. There was no current address. They couldn't find them. And so those funds were being held. Those would still be assets of MP PPH that MP PPH would be entitled to retain and not have to refund if the tenant appears at some point and says, I never got my check, I'm entitled to it. MP PPH could keep those funds
Well,
because.
then explain to me also then how the liquidated trust, now, we've had this for less than 24 hours on our end, but there's a liquidated trust that has the retained causes of action. And if my rudimentary understanding of bankruptcy is correct, they could take this action over from you maybe, or any number of things. Is that not something for the liquidated trustee to deal with?
I think they could do that. I have to confess, I'm not a bankruptcy expert either, and I don't know what the precise procedural path would be, but the liquidating trust handles assets and other claims that MPPPH might have, and those are still pending in the bankruptcy court. The bankruptcy proceeding is not over because there was a sale of the property. There are still things that need to be done to deal with the assets of the debtor, and that would be one of them. And the liquidating trust would be in charge of that. What they might do to take over this appeal or take over the rights generated from this appeal, I think is a question. There also still is a pending proceeding in the Superior Court in which MPPPH is a party, and how that exactly is affected by this. I confess, I'm not a bankruptcy expert.
Well, what court do you think is the appropriate court to answer these questions?
There
There's
was
the Superior Court, there's us, and there's the bankruptcy court.
I think in the first instance, the bankruptcy court has to weigh in on these issues. And there was a lengthy proceeding in the bankruptcy court about the rent abatement, and actually the bankruptcy judge put an end to that as of December 1st of 2024, said those can't continue, but she made it clear that she wasn't prohibiting monetary claims from being pursued, a judgment from being entered against MPPPH on
So there's
monetary
no
claims.
bankruptcy stay that precludes us from ruling, you're saying?
I don't think so. The bankruptcy court made it clear that you couldn't act on, for example, if you obtained a judgment against MPPPH, you wouldn't be able to act on that to execute on it against the assets of the debtor. That's a matter in the purview of the bankruptcy court, but she wasn't saying there was a stay that prevented the litigation from moving forward, and it has been moving forward. And as we advised the court a few months ago, there was an order entered November 27th, 2024 by Judge Kravitz granting partial summary judgment.
Yeah,
And that's a
It
second.
was unclear why, I mean, this is sort of shifting to the briefing of the merits. There's a lot in the briefing about things that happened after the notice of appeal were filed. Not clear to me why that's properly before us.
It's an interesting case, and that's a great question that I'd love to discuss in detail, Judge Easterly, because not only is it the November 27th, 2024 order that is a grant of partial summary judgment, that is really the fruit of this poisonous tree, but
That is an issue for you to raise on appeal from that grant of summary judgment. That is, we're here on a notice of appeal from a contempt order.
I understand, and I think what we are hoping is that the end result of this appeal will be reversal and vacation of the contempt order, and
Well,
then.
let's talk about that. So it seems to me that.
Before we go there, can I ask one
Sure.
more question on the preliminary piece? Just to be clear, one concern I have, and maybe it's something for later, but you when we talked about this liquidated trustee, you talked about the trustee potentially having a right to come in and do things, and it's kind of a concern. So if you could briefly address it, why they're not the actual party in interest now. Like I'm concerned that we hear this, and then a trustee comes back and they can certainly adopt everything that MP PPH has already done, but they say, well, actually you heard this and we have something to say. And we took over rights as of the close of this sale on December 31st, 2024. So on January 14th, we should have had a right to weigh in before you heard anything. Is that an issue you see potentially here?
I don't. They're aware of this appeal. They've been aware of it all along. And if they thought there was a need to file a notice, they do this all the time when there's a claim and it's subject to the automatic stay in the bankruptcy court, they file
How
a
are they
suggestion.
aware of this appeal?
I have personally been working with them. My firm was appointed as special counsel in the bankruptcy, and we've kept them apprised of this entire proceeding. And in fact, bankruptcy counsel for MP PPH has attended many of the hearings in the Superior Court, and that's reflected in the transcripts. Judge Easterly, you had asked a question, and I want to make sure that I get to this point. Because we had the contempt order that was entered in April of 2023. We immediately filed a comprehensive motion for reconsideration, and we got a pretty quick smackdown, I would call it, from Judge Kravitz by an order on May 22nd, 2023, where he said, I could go through all your reasons in detail, but none of them are.
Right, we don't have any of the briefing for that. And so to the extent that you're trying to argue that he abused his discretion in denying you, I mean, we don't actually have motions for reconsideration, right? We have Rule 59, we have Rule 60. I have no idea what rules you invoked because we don't have the briefing for that. And I don't see in your brief where you explained how he abused his discretion under Rule 59 or 60, whichever it was that you cited. So I don't really see that as properly before us.
Well, we filed a motion for reconsideration and for stay, which is.
I understand you filed the motion for reconsideration and you might have even listed it in your notice of appeal. I won't fight you on that. You didn't provide us with any of the record materials that we could independently look at the exercise of discretion in that, just in whatever it was, a Rule 59 or Rule 60 motion. And you haven't cited, I don't know what the rule is and that you invoked, and you haven't briefed how the court abused its discretion, right? There's standards under those rules. And I just don't see that in your briefing.
Judge Easterly, we provided a copy of our motion in the joint appendix. We didn't provide the supporting memorandum.
Right,
Because we're instructed not to. It is in the record of the Superior Court.
We rely on the appendices in civil cases with paid counsel, and we don't have any of the materials, but more importantly, I mean, yeah, I guess we could go to the Superior Court docket and pull it. I don't see anything in your brief where you say under Rule 59 or under Rule 60, Judge Kravitz abused his discretion in denying the motion that the post contempt sanction ruling.
I mean, that's an argument that runs throughout our brief, and we talk
It's
about,
not really. I mean, usually parties do sort of drill down and say, look, the initial ruling was wrong. And then we explained to them why they were wrong. And then they didn't, because there was new law, or there was new evidence, or whatever the standard was that was meant under the rules. That's how we usually do it. So I think your time is better spent, even though we've already run out the clock, but we definitely want to talk to you about the merits, is better spent on talking about Judge Kravitz's contempt ruling, or the sanctions ruling.
right, and the nature of the relief that he granted, as we've argued, makes this a criminal contempt citation and not civil. Not just the size of the relief that he granted, but the fact that it wasn't conditional. He didn't follow the three-part test that this court has adopted, where drastic sanctions are imposed. In large part, the relief that he granted.
Well, that three-part test only it was in a case, even if we consider that not to be dicta, it dealt with coercive sanctions. These sanctions were supposed to be coercive and compensatory. Why do we need a three-part test when compensation is clearly part of it here?
Well, because it really isn't. It isn't compensation, because there wasn't any evidence before him on what would compensate the parties, which, by the way, was the district and MP PPH. The tenants who he awarded relief to are not parties and are not part of the consent order that was the subject of this. What he did was he granted immediate, irrevocable, non-purgeable sanctions that took effect right away.
I don't see that you preserved an argument to immediate rent reductions. So at the hearing on April 13th, it seemed like your main concern was the $5,000 a day fine that the district wanted to impose, and you said
Because that's all
that-
the
that would
district
be-
asked for.
that's incorrect. They asked for an abatement as well. They asked for an abatement in the future. Initially, I believe, starting at a lower amount, maybe 10%, and the district can correct me if I'm wrong, and then maybe going up thereafter. But they definitely asked for an abatement, and your argument was, or MP PPH's argument was that the fine would be crippling and wouldn't go to the tenants, but to the district. And that actually was, I believe, in your brief. And then at the hearing, the court said, well, what about an immediate rent reduction, which could be purged or stopped by the defendant in the event that the defendant came into compliance with the court's order, satisfied both legitimate purpose, and says that this would satisfy both the purposes of contempt, to coerce compliance, and to compensate the people aggrieved by the non-compliance. And the district says, yeah, that sounds good to us. And the court says, well, do the rent reductions only have to occur prospectively? Could the rent ledgers be adjusted? Could tenants be given credit? District says, yes, all that could be done. Court asks about the tenants who have left. The district says we could give them compensation. And at no point do you object, right? The only objection is to the $5,000 fine, $5,000 a day fine, because that takes money from the property, and that's your only argument. I just
But-
don't see that you ever challenged an abatement of any sort.
We certainly did in the motion for reconsideration. I don't mean to
In the
interrupt.
motion
Yes.
for reconsideration, yes.
But nobody had any notice that there was going to be a 50% reduction in rent going all the way back to June of 2022, that by its own very definition is not purgeable. It can't be purged because it's in the
Right, but then
past
you're
and it's
then you're
gone.
challenging perhaps the amount, which was new for you, but you seem now to be challenging just the general permissibility of a rent abatement as a sanction. And that was certainly before you at the hearing.
But I think it also depends on the size and the impact of the financial fine or reduction or whatever you want to call it, because the larger it gets, and there was testimony.
Right, no, but one of your arguments, I think your primary argument as to the rent abatement is that it's impermissible because it goes to a non-party and it's non-purgeable. And both of those questions were essentially before you at the hearing.
And I
you
think we
didn't
did
make it.
argue that, and if not, we move for reconsideration. We made
Well-
all
When
these
you
same
sit down, you
points.
can point me to where you did, but I looked at the hearing record and the briefing pretty carefully and I don't see it.
The,
So that's an unpreserved issue and generally we don't hear people on unpreserved issues. And to the extent that you say that it was preserved in the motion for reconsideration, you just haven't briefed why the court abused its discretion in denying that motion that we don't have the record for and that you don't even specify what rule you're.
and part of the record for that are the subsequent proceedings where Judge Kravitz explained what he did and why he did it, which he didn't do in response to the
But
motion
that's
for
not before us.
reconsideration. He
We're-
just denied it.
That, I mean, that is all after the fact, right? Post hoc.
That
and
doesn't
what
mean
we're
it's not
looking at-
relevant.
Well, but what you
It's
would have
not
to
part of
show
our
on
record.
reconsideration is why one of the things you would have to show on in a motion for reconsideration is why you failed. Good cause for failing to raise that argument initially. And I don't know if you did that in your motion for reconsideration.
I think we did. I don't think anybody had any notion that he was going to go back a year, cut the rent 50% based on things that couldn't be purged, couldn't be cured. I mean, he's even talking about the swimming pool not being open, which there wasn't clear and convincing evidence of.
The swimming pool is the least of anyone's concerns, I think.
Well,
I mean, the swimming pool is definitely part of the consent order, but I think there were bigger problems with the property. So to your extent that you're trying to focus us on the swimming pool,
It's just one example.
The judge had heard that there was a consent order with specific timetables and specific deliverables that you agreed to and that you didn't comply with over a very long period of time. This isn't just a do this and 30 days later you haven't done it and so we're holding you in contempt and imposing some sort of retroactive sanction. This is a consent order that was issued and over a year later you still weren't in compliance.
Well,
And you had filed a 15th, status report that showed that you weren't in compliance and it showed that you weren't going to be in compliance anytime soon. I mean, do you want to represent that after the consent order came into place, within 120 days or even after Judge Kravitz's sanction order came into a place, 120 days from that, you were in compliance with the consent order?
We were making diligent and energetic efforts to comply. There were things that were not completed. There isn't a dispute about that. But the question is, some of the things we did even before the consent order was entered, and he discounted that completely and said, well, you did it too early. Sometimes it was, you did it too late, or you only did it because the district filed this renewed motion, which Judge Pasachow, the prior presiding judge, had ruled on and said everybody was making efforts to comply.
Judge Pasachow didn't hold a hearing. I mean.
She did. She didn't hold an
And
evidentiary
she did
hearing.
not hold an evidentiary hearing. So, and she ruled, months earlier without an evidentiary hearing, did not have the full factual record that Judge Kravitz did. And he was free to make his own ruling. I mean, the emphasis on
But-
Judge Pasachow's ruling in the brief is sort of puzzling.
Well,
to me.
it's in part a fairness issue. We're told at the end of 2022 that
The
we're
fact that
making
Judge
efforts.
Pasachow is willing to give you more time at an earlier point in the schedule, and then Judge Kravitz looks at a much fuller record and says, you were way behind schedule, well beyond time, and have not made substantial compliance with these commitments that you agreed to, and no one forced you to. I just think it's apples and oranges.
He had testimony from 3 residents and he extrapolated that to over 2,500 people, past, present,
I know
and.
But you
that's-
would agree that something like all the elevators being out would affect all the residents in a particular building, right?
And there are 9 buildings, so if the elevators are out in a single building, it would affect that particular issue would affect everybody. But the law in
And
this
then he also
jurisdiction,
had the evidence on record that the full inspections that were to be done weren't being done. There were site inspections being done by individuals not licensed in particular trades and a variety of other things that, you know, even if we took the three residents out and we didn't consider their testimony at all, there were a variety of things that he could have based his ruling on, right?
no, I don't think so. He never had evidence. And the case that was decided recently by this court, Lynch versus Gata, is just one example. This jurisdiction has never accepted a one-size-fits-all evidence for housing conditions. You have to prove specific to each housing unit and each person, what happened, how long was the duration?
Well, I mean,
what
that
was
goes,
the-
that's a damages question, and that seems to undermine your argument that this was not an appropriate contempt sanction, because if the court instead had gone through 2,500 residents and figured out the damages that they had incurred, that would actually support your argument that this was sort of a damages compensatory civil penalty, I mean, a civil remedy, as opposed to a contempt, coercive and compensatory across the board sanction.
But the compensatory part of it, I don't see how you treat it differently. If it's compensatory for contempt, why is there a lower, different standard of proof than there would be compensatory for a substantive damages claim? There isn't any, the law in this jurisdiction has never said that there's a difference in that where we can have a one-size-fits-all because it's a contempt citation. I mean, in
Well, they're
fact,
not separate things though, right? It's both compensatory and coercive here.
that's what he said. I would say it's also punitive and penal, non-purgeable. I mean, it goes beyond
Yeah,
anything.
By definition, something compensatory should be non-purgeable, right?
Well, I guess you could look at that and decide. I don't know. I mean, there's no aspect of any of the retroactive relief that he gave that was purgeable.
I mean,
So-
you'd really have to launch an argument against the authority of a court to award compensatory damages as contempt sanction. And I mean, the case law is pretty clear on that against you, right? So,
in terms of the parties, but the tenants are not parties to the Superior Court case. And the consent order was only to resolve the district's motion for preliminary injunction. It was not to grant relief to individuals or non-parties or any of this.
The district
that-
is sitting parents patriae, right? And they're helping out.
They're saying that now. They didn't say that in the Superior Court. They've only said that on appeal.
I mean, but the district is a sovereign, right? And it represents the citizenry entirely, including the land, including the land, the entity to the extent is the District of Columbia entity and a citizen, because corporations are people too.
Right. They're not really much representing MP PPH in this, but I understand the theory. That's the legal aid made that same argument. But that ultimately may be where the merits of the case were headed. But now we've been short-circuited on the merits too by the exact same contempt order, which he used as the basis to grant partial summary judgment. But the consent order was never a vehicle to address damages, whether the district has the right to pursue them on behalf of citizens or not. It was never a vehicle for this. And to turn the contempt proceeding into a proceeding that essentially takes over the merits of a claim that isn't even before the court, that's part of the error in how Judge Kravitz approached this. And we certainly did make that argument to him repeatedly, and we argued the three-step process that's required, and that was in our briefing after the contempt evidentiary hearing in March of 2023. And I think when you look at what he did afterwards, and I understand, yeah, I mean, it's in the record and it gives you more color for how he reached the decisions he did. I mean, he's letting people, unidentified people, get up and essentially testify in open court without being put under oath, without cross-examination, and using that.
Seems like issues for another day. I think we have your argument, and we're gonna let you sit down now and we'll give you a few minutes on rebuttal.
Thank you.
Thank you.
Thank you, Your Honor. May it please the court. Marcella Coburn for Appellee, the District of Columbia. I do want to get to the merits, but I will first address the 28K letter and some of the mootness questions that we were discussing. The reason our letter was sort of couched, as you described, Judge Easterly, and the reason that we also did provide some of the documents from the bankruptcy proceeding, is that we had some of the same questions that the court was asking here about the availability of possible relief based on those proceedings in the sale. I did not hear anything from the owner that would explain clearly why they would be able to get relief for the rent abatements. But, you know, to the
The district was part of this agreement to allow this sale to go forward.
yes.
And I mean, was there any, I guess I shouldn't be asking for extra record information, but is there anything in the materials that you gave us? Are you aware of other materials that could be provided to us in another post-argument submission that clarify what happens, what was anticipated to happen with this litigation?
What we provided the
I'm
court
not
was.
asking, did you
yes.
forget about us? But,
Yes.
but I'm asking, did you forget about us?
No, Your Honor. There may be other attachments to the confirmation order that may address, for example, the retained causes of action that you were mentioning, Judge Howard. But again, when I looked over those documents, and I'm not a bankruptcy expert, but when I looked over those documents, I did not see, for instance, in the retained causes of action, possible actions against the tenants,
Okay.
for instance.
So
So
those retained causes of action are referenced in these materials, but is there a separate document that defines what those retained causes
I
of
think
action
it may
are?
define what they are. I'm not sure if it lists explicitly what they are.
If we could be provided with that, I think that would be helpful, because it would be nice to know whether it says, you know, including but not limited to, or, you know, how it is phrased.
Of course, Your Honor. And if this court wants sort of separately from that supplemental briefing on these issues, that would be fine with us. We would ask that we be able to respond to the owner's submission, just because it is not clear to us what their argument would be for what those retained causes of action would be. So we would appreciate the opportunity to
I'm
be
a
able to
little
respond.
confused though by the timing of all of this. I mean, I realized the sale was only closed a few days ago, but the agreed order from the bankruptcy court was back in September, which set forth all of these issues and the provisions that are what we're grappling with right now. I mean, why is this only raised yesterday?
That's right, Your Honor. The confirmation order was entered in September. It is my understanding that it was contingent on the sale actually going through. And so until there would be no effective date for any of this until the closing of the sale happened, which was December 31st. And I do apologize for the lateness of the letter, but as we were grappling with these issues and the effect of the sale, we did want to make sure the court knew, even though it was yesterday. I did want to make sure the court was aware of that.
So does DC at this time have a stance on the question I raised about the liquidated trustee versus MP PPH being able to do anything here? Is there a potential other party and interest in your view?
I don't know, Your Honor. I think that is a better question for the owner. I'm just not sure. But as I said, I do want to get to the merits. The owner of Marbury Plaza has flagrantly and extensively violated a January 2022 consent order that required it to remedy complex-wide housing violations, impairing the health and safety of more than 2,500 residents. Judge Kravitz found that the owner's abject contempt for the court's order led to pervasive mold, floods, leaks, insect and rodent infestations, malfunctioning plumbing and HVAC systems, broken elevators. The 50% retrospective and prospective rent abatements he imposed were carefully considered to accomplish the twin aims of civil contempt, compensation, and coercion. They were well within his considerable discretion, and this court should affirm. So I would like to discuss, if I can, some of the specific evidentiary support for the across the board compensatory rent abatements. I think the owner is arguing that there wasn't sufficient evidence that this affected the tenants, but if I could just point the court to a few citations in the supplemental appendix. First of all, the mold contamination is obviously a serious threat to all the tenants. One of the assessors, as predicted by them, found mold in every unit it worked in. That's in appendix at page 98. And the consent order, as of the time the district filed for contempt, 0% of the common areas in the entire complex had been assessed or remediated for mold. Less than 5% of the units had been remediated by the 90-day deadline. And even as of the time the district filed the contempt a year after the consent order, only 18% of units had been remediated.
I think we can probably agree that all of the units were affected and all of the residents were affected to some extent. I think the question is, and I think we can all agree that compensation is a permissible aspect of a contempt sanction. I think the argument is usually you have a plaintiff, or the party seeking contempt, who can show some level of damage, probably isn't the right word, but loss that the compensatory aspect of the contempt sanction is meant to address. And that party would come in and say, we lost X amount of dollars, compensate us for that, and that's an appropriate contempt sanction. Here you've got a slightly different situation where, and I realize the district was acting in parens patriae, but you've got residents, we all agree that they all suffered, but how can we tie a compensatory sanction to all 2,500 residents and arrive at an appropriate amount that we can sort of give approval to as a compensatory sanction that is also not purgeable in any way?
A couple of things, Your Honor. I think, first of all, the fact that this is an abuse of discretion standard is helpful, because in that situation, it means that there could be multiple correct compensatory civil contempt sanctions, a range of available exercises of discretion. And I think specifically in the rent abatement context, as this court has said recently in the Lynch case that the owner has helpfully pointed out, rent abatements themselves are not an exact science. Even in those situations, it's not like you're ticking through and saying, okay, $100 off because your stove didn't work for a week, $200 off because your roof was leaking. In that case, what the court has specifically required in Lynch is that the court consider the nature, duration, and severity of the violations, and then make a, quote, logical connection between the violations and the abatement awarded. And I think here, given the severity, and we're not just talking about mold in every unit, we're talking about hot water interruptions, constant leaks, floods, water intrusion, broken elevators, laundry room that didn't work for 1,000 residents in one of the high-rise buildings, not to mention the rodent infestation and the insect infestation that affected not just all the units, but also the common areas. I think in that case, as Judge Kravitz said, the severity of the unsafe and unsanitary conditions, all of which the residents suffered through because of the owner's abject contempt for the court's order, have greatly diminished the value of the residents' tenancies.
So help me with one thing on those actual evidentiary points that you're putting out. I agree, and I saw in the supplemental appendix before that you had the assessment that mold was essentially everywhere. I also acknowledge that part of the argument is, well, they didn't do some of the assessments for the other things like plumbing truly, so we can't even assess whether that is truly everywhere or not, and so that should be on them. Where, for some of the things like rodents, which I don't doubt are throughout the building or elsewhere, where is that in the evidentiary record that in a reliable way that shows it's truly everywhere?
Sure. So with respect to the plumbing and the leaks and the floods specifically, I actually think there is some evidence of the record showing that these are system-wide problems. There is testimony in the March 13th hearing at page 147 explaining that the hot water system goes to all buildings and gets piped into even the garden apartments from around the tower buildings area. So the problems that were identified with that and that we identify in our brief, I think there is evidence it's complex wide. But with respect to the rodent and the insect infestation, At JA 78, the DCRA inspectors had been finding violations throughout the complex for years. There was also testimony about rats in common areas. And so I think the testimony about rats in common areas, which here was the parking garage and the dumpsters, goes to show that this is a complex-wide problem. That's in the March 13th transcript at page 123. And I think also we know about, I think we know from the nature of vermin and insect infestations that they are often not localized to one area, particularly here where they're so severe. And I think the terms of the consent order itself, which again, the owner agreed to, also shows that it's a complex-wide problem, because what the consent order required was 6 months of ongoing treatment in all units and all common areas, and then thereafter at the resident's request. So I think all of that goes to show that this was a complex-wide issue.
So alternatively, though, you would argue that, mold alone being a threat to health would be a sufficient thing that you would think it would deprive you of, in some cases, all value of an apartment unit.
Well, under the Tenant Receivership Act, it does define mold contamination as a serious threat to the health and safety of tenants. And I think in this case, as I think we all agree, there was mold everywhere. And in part, it was because of the continuing water intrusion. That was also an unremedied problem because the owner never did the assessments and certainly never did the kind of full-scale replacement that was required. And so, like I said, this is an abuse of discretion standard. And Judge Kravitz had all of this evidence before him, not just evidence from the tenants, which was extremely useful, but also the owner's own monthly reports detailing their failures to comply with the consent order. And they, of course, Judge Kravitz also had before him testimony of the owner's own employees and their own witnesses, many of whom also testified to work stoppages or failure to fully fund the recommendations that they made for replacing the building-wide systems. So again, I think my point there is that this is an abuse of discretion standard. A 50% rent abatement is amply justified by the evidence retrospectively and prospectively as a coercive matter. I do also want to touch on the question about whether this was a criminal sanction as opposed to civil contempt. I think this court recently in the CC case explained the factors that the court should look at in determining whether contempt is civil or criminal. In this case, the order or the contempt was intended to be compensatory. I don't think there's any question about that. It was not payable to the court. It was not payable to another party. The owner makes a lot of arguments about how the tenants aren't parties to this case. But I think the important part of that analysis is that it wasn't payable to the court. It was payable to the individuals who were aggrieved by the violation of the consent order, which is the tenants. And again, in addition, the owner argued to Judge Kravitz that there should not be money paid to the district, that any money paid should go to the tenants. So it doesn't really make sense for them to be arguing now that actually no, money could not go to either the district or the tenants. I think this court's cases are quite clear that the aggrieved individuals who are harmed by the violation of an order can be compensated by the court, and that is obviously here the tenants. And of course, the consent order was entered for the benefit of the tenants because the reason that all of those housing violations needed to be abated was because the health and safety of the tenants of Marbury Plaza, 2,500 people, was at risk because of the inactions of the owner. So, those are the first couple factors in CC. Parts of the rent abatements also sought to coerce future compliance. The prospective rent abatements were clearly, partially at least, coercive. The opportunity to purge, as in CC, at least with respect to the compensatory part of the sanction, that's not relevant. They're obviously compensatory sanctions don't need to be purgeable. That's the opposite of what they are. And then the only remaining factor is whether the sanction is substantial. I think in this case, given the scale of the problems, a 50% rent abatement was perfectly reasonable and not anywhere near some kind of punitive sanction on the owner. It was appropriately compensatory and coercive. And I think the final point that I would make if the court doesn't have any further questions is, to the extent that the owner is arguing that the magnitude of things that they had to do here is somehow a defense either to contempt or the particular contempt sanctions, that can't be the right answer. These are problems that the owner has created by failing to comply with the consent order, not just for 30 days or 60 days or 90 days, but for over a year by the time the district moved for contempt. And so for all of those reasons, Judge Kravitz was well within all of the discretion that he had to impose these reasonable contempt sanctions. Thank you.
I just have
of
one
course.
question before I let you sit down. Do you think that sort of the overarching challenge to the rent abatements as a relief going to tenants, as a non-purgeable sanction because they're retroactive, do you think that's preserved on this record?
We argued, as we argued in our brief, I don't think so, because they had the opportunity to argue that in the hearing on April 13th. They didn't the owner made no arguments that that was not allowed. They didn't file anything afterwards saying that was not allowed. And to the extent that they did raise it in their reconsideration motion, which I confess I'm not entirely sure of, arguments about the reconsideration motion aren't in their opening brief. So I think, I think there are plenty of reasons why on the merits that argument should be rejected, but I do think there's a serious forfeiture question.
And just one procedural question, after the hearing, after the contempt hearing, there was a post-hearing briefing, and was that sequential briefing? Because in the district's brief, it argued for an abatement. I believe that the company's response came after, but was it sequential or simultaneous?
I'm not sure, Your Honor.
Okay.
But I think the point is that they certainly knew about the 10% abatements, at least by the time of the April 13th hearing, if not before that in the briefing, if it was sequential. There was no question that rent abatements at least were on the table. What Judge Kravitz then specifically asked the district and gave the owner an opportunity to talk about, and they didn't, was retrospective rent abatements. Thank you.
DC also laid out not just a 10% request, but requested that elevate to 30 and then to 50. And
Yes.
so higher numbers were there as well, right?
Yes, certainly. The availability of 50% rent abatements was clear to everybody. Thank you all.
Counsel. Mr. Johnson? Oh, I'm so sorry. I apologize. Now we'll hear from Ms. Shea.
May it please the court, Catherine Shea for Legal Aid DC. The issue of mootness has come up in today's argument. Given the complexity of the bankruptcy litigation, Legal Aid cannot definitively say that the issues before this court are moot. That said, the landlord has yet to articulate how a victory on appeal would provide it with any concrete benefit. Particularly troubling to Legal Aid is the landlord's assertion in its most recent filing and an argument today that the tenants that the landlord would somehow be able to recover from the tenants. Any claim against any tenants have been clearly discharged in the bankruptcy order, which the district attached to its most recent filing. Specifically on page 34 of that order, it states that the retained causes of action shall not include any claims or causes of action against current or former tenants, and no claims or causes of action, including without limitation, collections actions, shall be brought or pursued against current or former tenants by the debtor or the liquidating trustee. Putting aside the issue of mootness.
Well, just on the point, I mean, so you say that Legal Aid can't take a position, but then you sort of make an argument that this is moot and generally, and then you also say that the company hasn't shown that it isn't moot. Generally, we require the party asserting mootness to prove mootness or to demonstrate mootness. And so we're sort of in an interesting position where both the district and Legal Aid as amicus have sort of waived mootness, but haven't actually moved to dismiss the appeal on mootness grounds. And actually, I'm not sure that amicus would be able to, but certainly amicus could support that argument by the district. It hasn't been made. So I'm not sure where that leaves us.
Yes, Your Honor. I do think, as the district pointed out, in order to really address the issue of mootness, we first need the landlord to articulate how they intend to benefit from the appeal. And I don't, and well, the landlord has suggested a limited number of ways in which it could recover. They haven't so far articulated a valid method of recovery. As I pointed out, their assertion that they could recover from the tenants, certainly, and that's legal aid's role as an
Right,
amicus.
I understand that, and I don't mean to make you repeat your substantive argument. It's just sort of procedurally, we're in a sort of odd position where arguments are being made about mootness, but no one's actually moved to dismiss the appeal on mootness grounds. So with that observation, I'll let you get to the merits.
Yes, putting aside the issue of mootness, legal aid has joined as amicus in this case, primarily to provide a voice for the tenants of Marbury Plaza. The landlord has opposed the rent abatements granted to the tenants as a contempt sanction. They primarily opposed it on two grounds. First, the amount of the sanctions, and second, who the sanctions go to benefit, which are the tenants of Marbury Plaza. I'll address both points in turn. First, the landlord inexplicably calls the 50% rent abatement in this case unprecedented, devastating, improper, untenable. However, a 50% rent abatement is, if anything, moderate in light of the conditions that the tenants of Marbury Plaza have endured as a result of the landlord's utter contempt for the consent order. Marbury Plaza is a veritable checklist of unsafe and unlivable conditions, including a rat infestation, mold, faulty pipes, repeated flooding, broken elevators, and a broken wheelchair lift that have left many tenants prisoners in their own home. Based on the landlord-tenant precedent cited in our brief, as well as the need to coerce the landlord to comply with the consent order moving forward, both of these factors more than justify a 50% rent abatement. Second, the parties are in agreement that a monetary sanction is a proper contempt remedy had the district been the beneficiary. But the landlord now attempts to argue that it is inappropriate because it goes to benefit the very people that were harmed by the landlord's contemptuous conduct. It is, of course, the residents of Marbury Plaza that have continued to endure unhealthy and unsafe conditions as a result of the landlord's abject refusal to enforce the consent order provisions to which it agreed. The purpose of the statutes at issue in this case are to benefit the tenants and consumers, in this case, the tenants of Marbury Plaza. One of the purposes of civil contempt is to compensate the victims of the violation of the court's order. Again, that is the tenants of Marbury Plaza. Indeed, even the landlord recognized that the proper question when formulating these contempt sanctions was, how does it benefit the tenants? It asked that question directly on March 13th at page 18 of the transcript. Having admitted that the tenants are the proper beneficiaries of contempt sanction, the landlord should not now be heard to say that the tenants are entitled to nothing. The trial judge enjoys broad discretionary powers in designing appropriate orders for contemptuous conduct. The landlord's willful failure to abide by the consent order has had severe consequences for the tenants of Marbury Plaza. And the sanctions imposed are an appropriate remedy for that harm. We ask that the court affirm the civil contempt order.
Thank you, Ms. Shea.
Thank you.
Mr. Johnson.
Thank you. Judge Shanker, I thought a couple of your questions in particular get to the heart of one of the key issues, which is the sufficiency of the evidence to meet the clear and convincing standard. Of course, this is an abuse of discretion review, but the evidentiary hurdle that had to be cleared below for contempt was clear and convincing evidence, which this court reviews de novo whether the evidence was sufficient, and it simply wasn't. 2 citations were made to the appendices in the earlier argument. One was to page 98 of the supplemental appendix. One was to page 78 of the joint appendix. Neither of those are evidence. The joint appendix citation is in fact to the district's first amended complaint, which are just allegations of the district. That's not evidence of anything. That's not evidence that was offered or received at the contempt hearing. The citation to the supplemental appendix, page 98, is one page out of one of the monthly reports that just reflects some of the analyses that were done of the plumbing and the other conditions at the property. Neither of those are evidence of anything. There wasn't evidence in this case sufficient to show a diminution of value of tenancies for 2,500 residents currently, past residents, or future residents, that the
Well,
landlord.
that's conflating it a little bit, isn't it? Isn't the clear and convincing, doesn't that go to the violations of the order itself? But in terms of crafting that remedy, what we're looking at is an abuse of discretion and whether the trial court was within its general reign. And I think the fact that it's both compensatory and coercive probably gives them more leeway than trying to calculate a damage remedy.
Well, I'm not sure, because the compensatory part, I would argue, the standard of proof for anything in the context of a contempt proceeding is clear and convincing. It's certainly not preponderance of the evidence. And
You think there's a clear and my understanding is that you have to show clear and convincing evidence that the order has been violated such that the party is in contempt. Do you think that there needs to be clear and convincing evidence of the particular remedy that the court?
I think there
endorses?
does.
Do you
And
have a citation for that?
I think in all of the contempt cases that this court has decided, it's always a clear and convincing standard.
For the actual sanction.
I
that is
believe
chosen.
I believe for every part.
We'll go back and look at our cases, but as for the clear and convincing evidence that your client violated the order, I mean, you're saying, I take it you're saying that there was not clear and convincing evidence.
There was
that-
not,
But
and it's,
in your brief, and I'm gonna hold you to your brief, I mean, I only see two places in your brief where you mention that there was a failure of proof by clear and convincing evidence, and it's one is about taking care of the pool, which we've already discussed, and one is about one witness's testimony about the chairlift didn't rise to the level of clear and convincing evidence.
I
But
think,
as we've already discussed at this argument, I mean, there are so many, there's a litany of problems with this property that go beyond one chairlift and, the pool. And
that's
it's
all
about
true.
Mold in every single unit, in all of the common areas, plumbing issues, non-working elevators, rats, at least in, the common areas of the unit, of the property. So, it seems like there's ample evidence from which the court could have found clear and convincing evidence, and I don't see you arguing in your brief to the contrary. And then the question is remedy. And once again, I don't see where you argued below that Judge Kravitz did not have the authority to order a rent abatement in any amount, retrospective or prospective.
We certainly did make the argument, and
Would you point me to
I-
the record where you did?
in the motion for reconsideration, I
The
know
motion
we did.
Before the motion
and,
for reconsideration.
And I would have to go back and look specifically. The evidentiary hearing was mostly an evidentiary hearing. We did point to the fact that the court
Right, you were
was,
talking about sanctions at the evidentiary hearing, and I'm not looking for those arguments at that proceeding. But after the evidentiary hearing, there was post-hearing briefing in which the district asked for a rent abatement that, started at 10%, went up to 50%.
and we
um,
filed a response to that, which
And you
is,
filed a response to that, and I don't see anywhere in that response that you said, oh no, there can't be a rent abatement.
and I know we were focused on the three-part process for civil contempt. We did file then a motion for reconsideration. I confess, I thought you weren't supposed to file to load up an appendix with memoranda that were filed below, because they are part of the record. We made a comprehensive motion for reconsideration where we set forth all these arguments, and we talked about each and we do in our brief, there were 16 things that he said were violations of the consent order, which went even beyond what the district was arguing. And in some instances, he found that our compliance was encouraging, but we're only started working more diligently and energetically after the district filed its renewed motion. Some things he found he disregarded because they were done before the consent order was entered. Some things he found and sanctioned on were based on this idea that the consent order was entered in January of 2022 when it was actually entered in March. And the compensatory part of it, there just isn't evidence to show that for 2,500 people and past people and future people, there was.
I mean, it seems, so if you accept that compensatory relief is permitted as a sanction for contempt. And
To
you,
the parties.
no, well, just hear me out.
Understand.
And you accept, which arguably you did in the trial court when you said the relief should go to the residents, not the district. You accept that in these types of cases, at least, the compensatory relief should go to the residents. Then you seem to be arguing only that in maybe there's a 5-unit building, then you bring in all 5 residents and they can testify. But that residents in a sprawling giant complex are out of luck because, I mean, we all know a trial court can't bring in 2,500 residents to testify individually about the level of damage that they incurred in their specific unit. So given what I would argue are 2 concessions on your part, you seem to be saying that these particular residents are out of luck because they happen to live in a giant apartment complex.
Well, I have to say, we didn't say sanction us in a way that rewards the tenants instead of rewarding the district. We argued there should be no sanction.
Yeah,
And
but
we did point out that if the district gets the money, that doesn't benefit the tenants. That's not saying give the money to the tenants instead. And it's not saying opening the door to 50% reductions past, present, and future. And that goes beyond anything that anybody could have envisioned. It's just, there
I mean,
was.
you did say in your closing brief, which was filed after the district filed its brief, asking for the $5,000 a day penalty and possible rent abatements. You said, if the court grants the district any monetary relief, the owner requests that it be for the benefit of the property and the tenants, not
But-
the district.
But we weren't waiving our argument that there wasn't, and we had no idea. Judge Kravitz went and did something
We would
that
call
nobody.
we would call that a forfeiture, where someone says, we would like a rent abatement for the tenants, the district suing, your company on behalf of the tenants, says they want a rent abatement, and you don't argue that the court is not entitled to impose a rent abatement, and then says, the owner requests that any monetary relief be for the property and the tenants. That's a forfeiture.
There's no way that's a forfeiture on anything that opens up him to do anything he wants in terms of the rent, including.
Well, then you're just talking about
amount.
amount, right? I mean, you're not talking about the permissibility of ordering relief directed to a tenant. I mean, if you had a 5-unit if your client were a 5-unit building and the court had ordered 10% rent abatement for those 5 residents, the only way you would be able to preserve the argument that you're making now is to say that too is impermissible. And it didn't seem like you made that argument below.
Well, maybe in the section that Judge Easterly is quoting from, we didn't say that, but we certainly did say that. And the other thing that Judge Kravitz did, keep in mind, there were cases that were decided where there's a procedure in the landlord-tenant court where there's a Bell hearing. He basically changed the result going back to June of 2022 in cases that had already been decided by other judges based on evidence specific
sure.
to this.
Change any ruling by any judge. He ordered you to tell the court and to tell the tenants that you were giving them these abatements.
And he ordered us to go back and amend claims that had been
Yes,
pursued and
His work
decided
was
before.
directed entirely to you. Not to any, he didn't order any other judge in Superior Court to do anything. He ordered you to do things.
Well, he interviewed magistrate judges about what was going on.
That's
That
not
he
in the
said.
record before this case.
It's in the transcript of one of the hearings, but
That came after the notice of appeal.
Well,
So
I mean, the
it is
judge-
not in the record in this case.
I think it's an important point though, because, and I do want to be clear, if there was a case that went to a Bell hearing where a judge took evidence and decided, these are the conditions in this unit, this is the reasonable amount of the rent. And by the way, there is a presumption that the amount in the lease is correct. This court has held that several times. Most recently in the Brown case in 2020. He said that result is overridden by this 50%.
He said you have to concede that it is overridden because of the evidence that I have now heard here today before in this proceeding.
I don't know
Right?
how
That is, he said, right? I mean, who knows what happens in those proceedings and what evidence was presented and, what the tenant had the wherewithal to show. But in this proceeding, where the district was putting on the evidence, Judge Kravitz looked at that evidence and said, now I am saying, you entered a consent order. You said you would fix all of these things on a specific timetable that you agreed to. You didn't do it. And now I am saying they are entitled to a rent abatement and you have to tell all the tenants who have been subject to, non-payment of rent cases, eviction cases, you need to tell them so that they can act in light of this new information and take advantage of this rent abatement.
So for a case where there was a Bell hearing and a judge based on evidence specific to that tenancy and that tenant and the condition said,
Right, in the past. and
10%.
Now there's new evidence and a new factual finding and a consent order by you, right? Yes.
he's going retroactive and
He is saying that
overriding
you have
what
to
happened.
tell the tenants about this and that things will change in light of your concession.
He's
Yes.
overriding what was already decided. There's no way to parse that otherwise. I mean, he's
I mean, maybe
imposing.
I guess I don't see any problem with that if the facts change and you have to accede to those facts changing. Yes, that is your contempt sanction.
The
I
facts
thought you were,
didn't change.
I thought you were making an argument that he was somehow improperly exercising his authority over other Superior Court judges. He did not do that.
I think he did. I think he
Well, I want you
disregarded.
help me make this make sense. From my point of view, this looks really similar to what we allowed in Lowinger v. Stokes in 2008. I don't see where he's overriding any other judge so much as giving effect to his judgment and requiring your client to notify all the other courts that this is the effect now. He's provided a remedy and now they are owed something for that time period. He's not changing the underlying ruling from the other judge. He's changing one of the facts that it may be based on.
I think Judge Howard, and I think there were two things in Lowinger versus Stokes that Judge Kravitz ordered. One was in cases where a landlord-tenant action had been filed for possession, you have to notify those courts that there's a receivership and make sure that you comply with what the rules require where a receiver has been appointed to manage a property. So that was one requirement. The other one was there was one specific case where during a discussion in court, the lawyer in question had indicated he was going to dismiss the case. And Judge Kravitz followed up to make sure that that was done as promised, but it isn't something that he directly ordered. What he did here, I think, is far more extensive and worse, which is he wiped out a year going back retroactively of things that had already been litigated and decided and said, here's the result that I'm imposing based on what I believe is the current situation, but it has nothing to do with evidence that was offered, received, ruled on over the past year. He most certainly changed the outcome in cases that had already been decided. And that's another way that this was overreach in terms of this order. He also, I want to mention before I sit down, he did award attorney's fees on the contempt, and to the extent that this order were reversed and vacated as we are asking, that's a relief that would be tangible relief to the appellant, as well as the fact that the same order was used as a vehicle to get to partial summary judgment. And I know this court is not going to reverse that. I understand that. But on remand, for further proceedings consistent with this court's opinion, I think it would be appropriate for whoever the trial judge is, it's currently Judge Williams, we would be able to argue to her that she should reconsider that order under Rule 54, and we could deal with that below. But I think there is a tangible redress that the appellant would receive if the order were vacated and reversed. The other thing I do want to mention, if there is going to be an argument of mootness, that typically would be something that would be presented by motion that we would have the opportunity to respond to and litigate, and to have it come up the way that it does when it isn't even.
Rest assured, we will not be, if we decide that mootness needs to be explored further, we will not just be making our own decision without further input from the.
Understood, and I didn't think so. But the point you were making, Judge Schenker, I think is entirely correct, or the questions you were asking get to the point that we were making, which is the evidence doesn't rise to the level of showing by clear and convincing evidence, or even I would argue by preponderance of the evidence, that there was a diminution of value for residents' tenancies retroactively and in the future. I mean, that is something certainly that we tried to call out to Judge Kravitz's attention and have him clarify, and he rejected it out of hand. And then it said at a hearing just a couple weeks later, he'd never even thought about the issue when it was something we argued in our motion for reconsideration. This order goes beyond any contempt citation in a civil indirect contempt situation like this that's ever been issued in this jurisdiction. The relief is not proportional to the harm shown, even if it is permissible to give compensatory relief to non-parties. And there's no case on all fours with this one that shows that this is a reasonable considered exercise of discretion. It's an abuse of discretion, and it should be reversed, and the order should be vacated. I'm certainly prepared to answer any other questions, and I appreciate the court's time and indulgence.
I think we have your argument. We appreciate your time today. Appreciate counsel's argument as well, opposing counsel's argument, and the case will be submitted. Thank you very much. The last case we have on our calendar today is 23 CV 445. Lauren D. BOUTAUGH, is that correct pronunciation? BOUTAUGH et al. Versus the District of Columbia.
Members of the panel, good morning. May it please the court, Matthew J. Fote for the plaintiffs. And if I would, I'd like to reserve 3 minutes for rebuttal at the end. We're here on an appeal from a motion to dismiss plaintiff's complaint under Rule 12(b)(6). Judge Williams found below that this case was barred due to a lack of duty owed on the part of the district arising out of the contentions in the complaint. However, the district was not entitled to dismissal of the plaintiff's complaint as a matter of law. To be certain, the appellants alleged beyond a speculative level all elements of a legally viable claim arising out of the minor child's death. Moreover, the public duty doctrine would,
Is that a question before us?
I don't think,
My understanding is that we have a ruling from a Superior Court judge saying that the public duty doctrine applies and that there's no special relationship between your clients and the MPD or the district, and therefore she dismissed on that grounds. I didn't understand there to be any other argument.
and I agree with that completely, that there shouldn't be any other argument. In the district's brief, issues of medical causation came up, which weren't joined below. Judge Williams, in her ruling, I think it's on the 10th page, did mention something about how she thought that this, that the COVID exposure came from Mr. BOUTAUGH as opposed to a cumulative theory, as opposed to some exposure at a prior time. But none of those issues were joined below. At the end of the day, Judge Williams's ruling was public duty doctrine.
I'm going to interrupt you for a second. Can we just check and make sure that the door out there is closed and that we ask the folks outside to move along because we can hear them inside the courtroom? Sorry to interrupt.
Oh, no
Go-
problem.
go
So no, I agree with what you're saying completely. Judge Williams's ruling is limited to public duty question, not medical causation questions, certainly not, do I think you're going to win at the end of the day? Right now, we have one issue before us. It's the public duty doctrine.
But what happens if the complaint can be read as alleging, I mean, you seem to just say, I think, I forget your exact words, but sort of a mixed theory of COVID exposure.
Well, if you
And
look,
so, sorry.
No. please.
So, I mean, to the extent there's a special relationship vis-a-vis Ms. BOUTAUGH, which the district seems to concede now.
Correct.
But the complaint, to the extent the complaint alleges exposure vis-a-vis Mr. BOUTAUGH, then, I mean, would you agree that the lack of a special relationship relied upon by the trial court would be a valid basis for dismissal of the complaint to that extent? Or how would that work?
Well, I would think that first of all, you have to look at the complaint that it's paragraphs 86 and 87 of the complaint. And there is a range of duties and breaches of duties listed there. Some having to do with Mrs. BOUTAUGH and what was happening at the 5D station in terms of the failures to do wellness checks, the incomplete medical histories that were being taken, the failure to do the required temperature checks, no PPEs, people being allowed to just come violating social distancing, a range of things that were ordered by the general orders. There was a series of general orders where the district and MPD said, we have said that these folks are essential workers. We need our police officers on the streets being able to work. So here are things that we're going to order that go above and beyond the general public to protect those. So take those. Another major one was contact tracing, which ties in Mr. BOUTAUGH. So if you look at paragraphs 86 and 87, paragraph 86 has A through L
Okay.
of things that are pled essentially in the alternative. You have ones sort of at the beginning of the chain, following sequentially all the way through to events at the end of the chain, where Mr. BOUTAUGH in December of 2020 developed COVID, and then.
So is the idea then that you've sort of pled to plausible alternative causes, either that Ms. BOUTAUGH contracted COVID in the workplace due to the breach of the duty to take care of her in the workplace, or that she contracted it through Mr. BOUTAUGH, who contracted it due to the breach of the duty to take care of him in the workplace?
To perform contact tracing, that would, and the whole idea of
So
contact
there's no, I
tracing.
mean, even
But
Right, it's interesting, the district has now conceded that there is a special relationship between Ms. BOUTAUGH and the district.
but I
In
agree with
relation
your,
to her employment. Sorry, I'm gonna get this language so that I don't muddle it. That they concede solely for the purposes of this appeal that the complaint plausibly alleges a special relationship with SMB through Ms. BOUTAUGH's employment with MPD. And I guess I'm wondering if she has a special relationship. Well, if SMB has a special relationship through her employment, does SMB have a special relationship through Mr. BOUTAUGH's employment with MPD as well?
I think it's, well, first of all, I agree. I was surprised when I read that in their brief as well. I think it's helpful for us. But I agree with your formulation in drafting the complaint. That's exactly the idea, was to start at the beginning and just go sequentially through to the end, pleading this alternative theory of exposure.
Well, maybe I made things confusing because I think I conflated two different questions. I guess,
Right.
you know, one, my question is your position that you've plausibly pled two different theories of causation and that you can now go to discovery and present experts and sort of prove up one or both of these theories?
Yes, and I think the Johnson case, I mean, there's not a lot of cases where the public duty doctrine is defeated. But there is that Johnson case where the court said, you're doing this on a motion to dismiss. We need to have a record. And if at the end of discovery, it doesn't make weight.
Well, I don't know why we need a special public duty doctrine case. If there's a concession that there's a special duty, it seems like.
Yeah,
they
then
just
it's- then
go
it's over
forward
at
Like
that
a regular negligence claim. They've, made their 12B6 argument. That's the only argument they made. And here we are. And now we move forward and maybe this, doesn't survive at the summary judgment stage, or maybe it does. I don't know. We'll see.
Correct.
But that's your position.
Correct. I think that's
Okay.
exactly it, is that, we have a task, an issue before us here today. And again, in the 12V6 jurisprudence, it says, we're not saying that you're going to win at the end of this. And we're not saying that because we don't think you're going to win, we're going to dismiss it now. So I agree with that formulation.
My separate question, I guess, though, is given the concession that the district has made that the complaint plausibly alleges a special relationship with SMB through Ms. BOUTAUGH's employment with MPD, are you here to argue or that there's a special relationship with SMB through Mr. BOUTAUGH's employment with
I think
MPD?
it's a derivative because you have SMB at one level, you have Mrs. BOUTAUGH at the next level, and then you have Mr. BOUTAUGH at the next level. And then you have the contract tracing regimen that MPD put into place. And the idea, and there's a site in our brief to a California Department of Health publication where they say, what is contact tracing for? Why do we do it? And we do it in order to make sure that family members get word that their loved one has been exposed to COVID so they can take appropriate steps. So the district, having put in place this regulation for contact tracing, saying to their police officers, look, we understand you have a job to do. You're going to be out there on the street, but we're going to encourage you to stay on the job, do your job well, because we're going to have this contact tracing that's not general public contact tracing. This is MPD contact tracing that our regulations putting in place, and we're going to protect your loved ones that way. So it's derivative. It's direct in a sense, but it flows to the family members.
But
And-
then
Go ahead.
then your argument, I mean, Miss BOUTAUGH in that situation, the fact that she's a police officer has no relevance to that theory, right?
Oh, no, it very much does.
Well, I mean, if the proceeding on the theory of exposure through Mr. BOUTAUGH and based on a violation of requirements contact tracing requirements, Ms. BOUTAUGH could have been in any profession at home and been exposed to her husband.
On that respect, on that sort of, if you look at it in terms of a chain at the end of the chain, then in theory, yes. But it also, you have to look back up one level of the chain and say, MPD has put this regime in place for the protection of their police officers. But with contact tracing, you're not just protecting the police officer, you're protecting the people who come in contact with the police officer. So on that
This
limited,
sounds like you're getting, I mean, we were talking, or at least I was talking about what the logical consequences of the district's concession, what that might be, right? So right now, they've conceded that SMB has a special relationship, that it has a special relationship with SMB through Ms. BOUTAUGH's employment with
Correct.
MPD. And now you're looking to the regulations, but, you know, to suggest that there's a special duty to SMB through Mr. BOUTAUGH.
correct.
But that is separate and apart from the district's concession. And generally, I think the district's argument has been, you can't create a special relationship by general orders or administrative orders. It has to come from legislation. So that's the first question, that if you're still arguing, if you're not just taking the district's concession vis-a-vis SMB having a special relationship through Ms. BOUTAUGH, and you're still arguing about SMB having a special relationship through Mr. BOUTAUGH.
Right.
What,
Well, I think it's still, it's the argument and the alternative. I mean, we're taught there are two sort of separate pieces. You have sort of the Mrs. BOUTAUGH piece of it, and you have sort of the Mr. BOUTAUGH piece of it. For purposes of the concession, I think it flows as to the Mr.
I mean,
BOUTAUGH
I'm
piece of
just
it.
wondering sort of, and I'll ask the district this, like, why does SMB have a special relationship with the district through Ms. BOUTAUGH by virtue of her employment? And if SMB has that special relationship through Ms. BOUTAUGH's relationship or employment, why not through Mr. BOUTAUGH's relationship? And maybe it's just like simple question of biology. I don't know. They'll tell me. But if we're putting their concession aside, I'm wondering, I guess, to put a finer point on it, do you still need or want to make an argument that there is a special relationship by virtue of some other, based on some other foundation, based on the Protection for Pregnant Workers Act, or based on regulations? You know, is there daylight between the duty that would flow under that special relationship and the special relationship that the district has conceded?
You know, you take your good news where you find it when you're up on appeal. You know, certainly, I think that the range, the whole, the range of special orders, I think the Pregnancy Protection Act is sort of a side issue in terms of it generating the exception to the public duty doctrine by statute, because it's not directly on point. It's not really like Turner or some of the other ones. I think the real action is with the MPD general orders, but I don't think that there is a lot of daylight there. And I think I do take their concession at face value that there is a special relationship. But then you go to the next step of reasonable reliance, and the reasonable reliance is missing.
Well, sorry, are we at reasonable reliance?
Well, if we've conceded special relationship, then we've got to have reasonable reliance to hit the second prong of that test.
Was that litigated below?
Not particularly, no. I mean, it was, you know, in the ruling, it was no duty. And then you have, as far as reasonable reliance goes, Ms. BOUTAUGH continued to show up at work, and I don't think that issue was really a key factor in Judge Williams's ruling. So, I mean, I think I agree with what the court's saying here. But my time is up, so if there are no additional questions, I'm just going to hold for rebuttal, and
We'll let
we'll
you
go from
get up
there.
on rebuttal.
Thank you.
Thank you.
Morning, may it
Morning,
please the
Johnson.
court, Holly Johnson for the District of Columbia. Causation is at the heart of the Superior Court's ruling. It's kind of buried in the language, but is at the heart of the Superior Court's analysis. Now, the Superior Court analyzed this under the special relationship prong. So I'm going to show you where it was under there, and I'm going to walk you through how you know that this is not dictum. And that because it is at the heart of the Superior Court's ruling, it doesn't matter that causation was not argued by the district below. It was passed upon by the court and is properly before this court. If you look at the ruling at JA 108, the Superior Court addressed special relationship in a different order than the way we did in our brief. It started with the Pregnancy Act. So what it said was that the harm, and this is where it gets into, it's a long paragraph. So if you start with the words, this is not a reasonable accommodations case, it's like the middle way through the paragraph. And then you can skip down a little bit about what the plaintiffs are alleging. It starts with, moreover, the harm to SMB has no relationship to Ms. BOUTAUGH's status as an MPD employee. And then the court goes on to give its causation, cause in fact ruling that it's not the workplace that at least the complaint does not plausibly allege that the workplace was the most likely cause of infection. Now, if you go to the next page.
Well, can I just stop you right there?
Sure.
I mean, I appreciate your acknowledgement that the district hadn't argued causation to the court. And so this statement about what the BOUTAUGHs are alleging as far as how Ms. BOUTAUGH contracted COVID was not in the district's 12B6 motion, was not addressed by Ms. BOUTAUGH. But I just think that the court's reading of their complaint is just a complete misreading of their complaint. And let me just point you to where I'm looking, right? If you look at paragraph 2 of the complaint, it's this, the introduction says the district failed to take appropriate action to protect Ms. BOUTAUGH from exposure, including allowing her to work from home, enforcing a mask mandate and quarantine procedures. Then in the facts, it talks about her not being able to telework at paragraph 22. At paragraph 28, it says she was required to appear for work in person at the 5th District HQ where policies and procedures were put in place to prevent COVID infection, but were being routinely broken or ignored. Paragraph 29, the 5th District repeatedly failed to comply with MPD's general orders concerning mask wearing, contact tracing, social distancing, health assessments and or temperature checks, self-quarantining, and limitations on access to the 5D administrative offices, thereby putting pregnant sworn officers working in the administrative office, such as Ms. BOUTAUGH, at undue risk of COVID-19 infection. Talks about her temperature being taken erroneously and sort of by implication other people, their temperatures were taken erroneously, talking about people having health screening in the building instead of before they walk into the building. Talks about access to the administrative office for the 5th Division where she worked, not being appropriately limited. Paragraph 35, the safety shields were never delivered. And talking about all of these policies in paragraph 36 being meant to protect those pregnant MPD officers still required to work in MPD offices and or facilities. And that's just the facts. And then you go to the cause of action and it lays out that, it was this breach of all of these policies, right? That they had this duty, these duties, these were the breaches, and that the cause was a result of the breach of these duties. I mean, that's pled. So to say that, and sure, there's stuff in there about Mr. BOUTAUGH getting COVID and contact tracing and not being advised that people that he worked with had gotten COVID. But there's also information about when she last worked on the 18th, when she became symptomatic on the 20th. That indicates that she could have gotten COVID at work. And so it just seems like a total misreading of the complaint for the court to have said in this section that's it's only really about the parties not having a special relationship under a statute or regulation, to say that the fact that Ms. BOUTAUGH also worked for the MPD is irrelevant. I just don't see that it's irrelevant. I think that it's at the heart of her complaint that she has adequately pled that there was a special duty by virtue of her being at work, and that that was breached, and that there was, and that she contracted COVID, and that her baby died as a result of it.
And if the court can bear with me for like 10 seconds to finish my thought on what the Superior Court ruled, because I want to make it clear that this is not dictum, this is the heart of the
No,
ruling.
but I'm just pinpointing that
Absolutely.
that statement and saying and to the extent that the court then says other things that are premised on that misreading of the complaint, that seems problematic to me. But I just want to show you that on page 10, when the court is saying this about her relationship with MPD being irrelevant, that seems to be a fundamental misreading of what Ms. BOUTAUGH has pled.
Well, and I'm fully prepared to argue about the merits of the complaint. I just want to finish my thought about what the Superior Court ruled.
I think we're
Because
pointing it out to you because we agree with your thought that it's in there and it's said.
it's just literally one sentence. I just want to point this out because this isn't just under the Pregnancy Act. The court raises it again under the common law special relationship on JA 109, where the court says, and this is after it makes its cause in fact ruling under the Pregnancy Act, it says that it basically is only going to consider Ms. BOUTAUGH's common law special relationship, and I quote, in her role as a family member of an MPD employee. So that's why I want to make clear that it's not just a ruling under the Pregnancy Act, that under the special relationship, he says, I'm not considering her relationship as an employee because of the causation argument. Now I'm happy to turn to the
And,
causation.
and now let's talk, I mean, it's not a causation argument. It's like, it's sort of what her duty breach causation argument. It's her negligence claim. And she is saying, you were negligent because you allowed me to get COVID and then my baby died.
I
right?
understand. And so
like the fact that the court says it twice. Anyway, let's talk about the complaint.
I'm happy to talk about it. And as you can see in our brief, we lifted this out of the special relationship prong because given our concession regarding the special relationship, it doesn't matter whether the court considers this under a straight negligence case or under a special relationship. It's the same either way. So we think this is the rare case in which dismissal on causation is appropriate at the pleading stage. And that is not because, and I want to make this clear, that is not because the BOUTAUGHs did not assert a theory of causation in their complaint. It is because the facts alleged in the complaint make it impossible for them to prove ever beyond a speculative level that Ms. BOUTAUGH contracted COVID at work. Because the complaint affirmatively says, and she's bound by the allegations in the complaint, because it affirmatively says that she was exposed to COVID at home to the fullest extent one can be, she cannot ever and the complaint does not plausibly allege, and she cannot ever prove that it is more likely that she contracted COVID at work. And
I just don't know that, right? Like at this point, and I'm not a doctor and I'm not a scientist, but I lived through COVID and I know that there was some latency period. And I don't know whether an expert could show up and say, look, if her exposure in the workplace, happened on the 18th and she became symptomatic on the 20th, and her husband became symptomatic or tested positive. Now I can't remember on what day.
the day before, he was symptomatic the day before.
He was symptomatic the day before. That, like, I don't know. Could an expert say, it is more likely than not that she contracted COVID well before, the day, that she contracted COVID on the 16th or the 17th or the 18th. But it is highly unlikely that she contracted COVID on the 19th and became symptomatic on the 20th. I have no idea. And I just don't think that we are there yet. I mean, this wasn't litigated by the district. I don't think it was seriously considered by, it wasn't considered by the court. The court just said, she is only alleging a relationship or infection from him. And that's not what she is saying. I hear you saying she can't prove it, and maybe she can't. But the court didn't say she can't prove it.
I mean, I'll say this one time and then I'll back off at this point. I think that if the court thought that if the court was not ruling on causation, it would have had to rule on whether she as a family, not as a family, whether she as an MPD employee had a special relationship. And the reason why the court never even considered that question is because at that point, it had already held that the question here was whether she had a special relationship as a family member of an employee.
Right,
Right,
because
right.
it's then the court was construing the complaint as solely alleging that she contracted it through her husband. And if that's wrong, then the court would necessarily have to be ruling that to the extent the court didn't address the question of whether if, to the extent the complaint alleged that she contracted it herself at the workplace, whether she could have or could not have proven at trial to a jury that, or at summary judgment, that she more likely than not contracted it at the workplace.
I see your point. I think that I always assumed, and perhaps wrongly, but I think that I always assumed the court, of course, was seeing that she is also alleging that she contracted COVID at the workplace for all of the reasons that Judge Easterly, the allegation is in the complaint. Obviously, the complaint alleges two different theories of causation. So my understanding was that the court was ruling that this is a case where because she alleges that she contracted COVID at home, that's the end of the story. She'll never be able to show it's more likely than not she contracted COVID elsewhere. But if this court is not going to reach that question, I think it's really important to talk about the other claim, because one thing that has struck me in this case is that it is going to be very expensive to litigate. It's going to be time consuming. It's tragic and deeply sad, and there's going to be a lot of emotional toll taken through litigation. And if this court were to address the contact tracing claim, which is separate and distinct. Let me back up a second. There's three theories of negligence, right? There's workplace safety. There's the requirement that Ms. BOUTAUGH work in the workplace, that she not telework. And then there's the contact tracing claim. Now, the first two involve the workplace. And if this court thinks that the complaint plausibly alleges that Ms. BOUTAUGH contracted COVID in the workplace, that is something that discovery could ultimately prove, then a remand on that claim is warranted. I mean, because we are conceding the employment relationship, the special relationship is at least plausibly alleged in the complaint. We're not making any concessions in future litigation, but
I did want to ask you why you were conceding it for the purposes of appeal and not more broadly the case.
my
But yes,
research suggested it's a
We under-
fact-based inquiry.
we understand that this is limited to the four corners of this
Thank you.
complaint and these facts.
So if, for example, the court were to rule on the contact tracing claim, which is, I mean, the other one doesn't really need to involve the public duty doctrine. The workplace safety, because of the special relationship, the court doesn't need to get into the public duty doctrine. But the contact tracing claim is very much at the heart of the public duty doctrine.
I'm sorry, I'm just not, I mean, I thought you wouldn't even talk about a special relationship unless the public duty, right? Like, so I'm just a little confused about how you're talking about it, right? I mean, if we look at Hood Boy, which is our latest word, and says, look, you have a negligence claim, and for the duty, you sub in, that the public duty doctrine applies, so there can be no duty, so your negligence claim fails unless you can show a special relationship, and then you have the duty that flows from that special relationship, and you get to show breach and causation as to that if you can show the special relationship, which isn't easy to do. So that's how I'm thinking about it, but you were just talking about like we don't have to get to the public duty doctrine, so I'm confused.
So it's not that the public duty doctrine doesn't play a role. It's that because the district is conceding a special relationship that would encompass the very duties that the BOUTAUGHs are arguing are direct negligence. The
Right.
court doesn't need to get into a question of whether those are direct negligence. It doesn't need to deal with the premises liability theory. It doesn't need to deal with the traffic light analogy. It can simply assume for purposes of this complaint or for purposes of this decision that the public duty doctrine applies, assume there's a special relationship, and move on. With the contact tracing claim, that's not true. First of all, the BOUTAUGHs have never alleged that The contact tracing claim involves some sort of direct negligence, that a failure to warn someone can put them in a worse place than if there had never been a program at all creating such warnings. And in fact, they raised that for the first time in their reply. And
But again, like that wasn't litigated below
yes, it was.
either, was it? I mean,
Whether this, I'm sorry, I don't mean to interrupt.
No. I mean, it's just, we're having a conversation and just my understanding is that the litigation in the Superior Court just seemed so kind of cut and dried of like, does the public duty doctrine apply? Yes, it does. Is there a special relationship? The district said, no, there's no direct and continuing contact and no, there's no like statutory special relationship, right? And the court said, you're right. There's no special relationship here. And now, we have a concession that there is a special relationship by virtue of there being a direct and continuing relationship via employment, put that to the side. And then there's the question, I guess, is what you're saying, like whether or not we look at the argument that was made below that I think is being renewed on appeal, but I'm not totally sure about that there's a special relationship by virtue of a statute or these general orders. Is that where we are, or you think we're somewhere else?
I'm going to confess I got a little lost in that. So I'm going to tell you where I think we are, and you can tell me if we're speaking the same language.
Just fine, thank you.
I want to start, and I think it's really important. The district did not forfeit an argument regarding contact tracing being covered by the public duty doctrine. In its motion to dismiss, it said.
No, I don't think so either.
Okay.
I'm assuming the public duty doctrine applies.
Okay. So that was an argument that I was wanted to pursue to you because, of course, the plaintiffs are arguing that the public duty doctrine does not apply because failure to warn Mr. BOUTAUGH, in fact, somehow amounted to direct negligence. They raise it for the first time in their reply brief. If the court doesn't want to consider it, we think it's forfeited. We also think it's nonsense that, of course, a failure to warn is a failure to protect from an external source. Now, assuming the public duty doctrine applies to the contact tracing claim, that's what we're talking about, that's when we need to get into the particulars of the special relationship, because there is no, even assuming that there was some duty, a special duty to Mr. BOUTAUGH to warn him about his exposure to some close contacts. The complaint does not allege any duty that MPD had to warn Ms. BOUTAUGH directly. And this gets into the question you were talking about. Who has the special relationship? Who does SMB enjoy the special relationship through? And I do think it's a matter of biology. I think that if SMB were not in utero, she would not have a special relationship through her mother. The reason why her mother's special relationship is imputed to her, and there's no case law on this. We're just assuming it for purposes of this case because the plaintiff's argument makes sense. That baby had no choice. The baby was along for the ride.
Right,
So,
but what if hypothetically, the baby is born, right? The baby is living with the BOUTAUGHs and is 1 month old and has, an undeveloped immune system. Thank you. And then, one or both parents brings COVID home and the baby dies at that juncture. I guess I'm just, wondering, like, given that you've conceded that there's a special relationship with SMB through the mother, does that mean that there is also a special relationship with SMB through Mr. BOUTAUGH as well? Why wouldn't there be? And maybe they haven't pled that clearly yet, but why couldn't they just, if we were to remand on the special relationship that's been conceded, why couldn't they amend their complaint and say there's a special, if there's a special relationship with SMB by virtue of the mother's employment, there's also a special relationship by virtue of the father's employment?
well, so I want to take a couple steps on this. Procedurally, I think that's foreclosed. The Superior Court ruled on the special relationship, said it doesn't extend to family. The plaintiffs don't challenge that. in their opening brief. And even if they did, it's something this court could rule on that would narrow the case. If they
But
wanted
the
to amend their,
superior- But the superior, I guess the foreclosure like is before your concession. And so that part of my question is based on like, okay, you made a concession and you know, look, you could take the position of like, look, we just made a concession as to this and nothing else, right? But logically, and this is where my hypo was going. I'm curious about the boundaries of the concession because it seems sort of arbitrary to say, okay, the district has a special relationship with SMB through the mother, but not through the father.
so one thought, and then I'll answer your hypo because I think that's important. The Superior Court absolutely ruled on this question because the Superior Court held that family members do not enjoy the special relationship. And here's why I want to get to your hypothetical. The Boutaughs had another child.
But this isn't about family members enjoying the, I mean, all I can say is this gets back to sort of the nature of your concession, which is that SMB has a special relationship with the district through the mother, right? And the district didn't, the Superior Court did not know the district was going to make that concession. And now that the district has made that concession, right? Because the district argued, no, there's no special relationship of virtue of employment. And the court said, yeah, I agree with you.
I don't think that's what the court said. I don't think the court agreed with us on that at all. I think that that would have been a surprising ruling. What the court said is that with regard to Ms. Boutaugh, it would only consider her relationship as a family member because of the causation argument. But I don't want to get into a long argument about what the court ruled on that. I think it's important.
Oh, sorry, you're right. Because the court misread the complaint. It didn't
So-
look at this. Yes. But now that the district has made the concession.
I don't think it makes any difference. And I want to be clear. So I want to sort of, I'm just organizing my thoughts for a moment. Okay. So a special relationship is an individual relationship. And that's clear from Hood Boy, from Platt. It is the contact has to be with the individual. This is a weird case because both of the plaintiffs, both of the parents are employees.
Right. Covered by workers' comp.
But the complaint does not allege anywhere in it that the district had a duty to tell Ms. Boutaugh, to tell her that her husband, not that he was infected, but that he had been in contact with someone who's infected. That's a third step, contacts of contacts. I mean, the complaint says,
But why are we talking, sorry to interrupt, but why are we talking about just contact tracing? I mean, why aren't we talking about just bringing COVID into the home and exposing, I mean, I guess exposing Ms. Boutaugh and the baby, but like,
because that's the only allegation in the complaint of bringing the COVID into the home. I mean, that the only allegation in the complaint, they're not alleging that Mr. Boutaugh got COVID because of, or they're not alleging that the districts, they are not trying to allege a causal link between Mr. Boutaugh contracting COVID, right? That the district somehow negligently allowed Mr. Boutaugh to contract COVID and then bring it to his family at home. What they are alleging, their only
aren't
claim.
they? I mean.
No, absolutely not. Nowhere in there do they allege that. What they say, and it's interesting, look at all the things they allege. They allege that Ms. Boutaugh masked everywhere, she socially distanced, she didn't go into stores. They don't make any of those allegations with regard to Mr. Boutaugh. They don't talk about where he went. They don't talk about how often he was in the 5th District offices as opposed to out on patrol. All they say with regard to Mr. Boutaugh, the only claim sort of linked to him is the contact tracing obligation. And the complaint is very clear. Well, to the extent it says anything about contact tracing, it says very little. It makes it clear that the notice was to Mr. Boutaugh. And JA 13, it says that Mr. Boutaugh was a close contact of the officers, but was not advised of their COVID status through the MPD contact tracing program. Had Mr. Boutaugh been timely informed through the contact tracing program that he had been in close contact, he would have isolated himself away from Ms. Boutaugh. So when we're looking at the contact tracing program, which is the only non-workplace related program, it's the only one involving the infection being brought into the home. The question is whether the district had a duty to Ms. Boutaugh or anyone else sharing a household with Mr. Boutaugh to tell them about his exposure. The complaint doesn't allege that. The Superior Court would not extend it that far because this wouldn't just extend to a young child. This would extend to any roommate that someone was living with. And what the Superior Court said is that would create this huge class of special relationships, and that is beyond the scope of what the public duty doctrine allows. Now, I'll tell you why it is that the district would like this court to separate out the contact tracing claim and rule on that under the public duty doctrine. The reason why is if this queues up a pure causation question, or there's a pure causation threshold in the Superior Court, then we can move to bifurcate in the Superior Court, and it would greatly streamline the proceedings so that none of the parties have to go through all of the experts. I mean, I literally counted up, I think there's going to need to be 5 different experts below. And if the case can be streamlined so that people don't have to go through all of that, it makes sense. And this is the only factual issue. The only fact thing that we ask the court to rule on is this causation question. Everything else is a matter of law, and that is perfectly appropriate at dismissal. You know, the BOUTAUGH claimed that it's unusual for this court to affirm dismissal of a public duty doctrine case. But of the 26 published opinions I looked at, 11 of them were affirmed dismissals on the public duty doctrine, many of them on the question of affirmative worsening or whether there was a special relationship. So what we would ask the court to do is, obviously, we think the court should rule on causation. I think that there's just no point in everyone coming back here in a couple of years about something that's just purely speculative. But I understand if the court's hesitation, it's an unusual situation. I've cited a few cases where the court has ruled at a 12B6 and affirmed dismissal, so it's been done before, but I understand that.
Clear that it wasn't briefed, that the court is reaching out and addressing it for the first time? Right, like that is part of my concern.
We think that the Superior Court passed on this, that it is at the heart, that it is literally the Superior Court's decision cannot be read without that. I don't think that the Superior Court could somehow read the complaint and be like, well, they don't seem to be pursuing a theory of workplace safety. Of course, they're pursuing that theory. What the court said is the facts here, you're saying she got COVID from home. And with those, the plaintiffs are bound by the facts that they allege. And once they alleged that she was living with a person who was infected with COVID in the days before she was infected, she could have shared a desk with someone at work who we know is infected with COVID. Like, I can't even imagine what the discovery could be that could possibly raise this beyond a 50-50 level, which is she has to prove it is more likely than not she got COVID at work. So we want the court to rule on that. We think that it would eliminate a lot of grief and a lot of waste of resources. But I understand if the court won't do that. That said, a ruling on the public duty doctrine on contact tracing alone, making it clear that the special relationship does not extend to anyone that an employee who was infected had continued contact with, would be incredibly helpful in narrowing this case.
Can you repeat what you said about when you would agree that a remand would be appropriate? You said if we were to construe the complaint as sufficiently alleging that she contracted COVID at work?
Yes, if the court thinks that it is plausible that at some point the BOUTAUGHs are going to be able to prove that it is more likely than not, beyond speculation, that she contracted COVID at work, then a remand for the work-related claims would be appropriate. Yes. Thank you.
Thank you very much.
Members of the panel, these folks over here lost a child. The idea that we should shortcut the proper process in this case to save us some trouble, save us some money, that's not what we're here for. We're here to do this the right way, and we're here to get to the bottom of this. That can't be the court's mindset here. Looking at Judge Williams's ruling, you got to read it in context. The one line that the district relies on is, it is indeed fair.
Let's say we agree with you, but on the point that the district is making, that we should at least affirm dismissal of any contact tracing claim. Would you like to respond to that?
I would, because I think the district is trying to have it both ways. I think they're trying to be, let pass the ones that they think they have the edge on, and narrow up on the ones that they think are a little more problematic. The issue is you can't have it both ways. You can't say in the same complaint, these are pled fine. This one limited issue is subject to a heightened pleading requirement beyond notice pleading where you have to say.
Well, is that what the district is saying? I mean,
I think
I
they
think
are.
the district is saying, we don't see where it is pledged that the district had a duty to tell Ms. BOUTAUGH about Mr. BOUTAUGH's infection through the contact tracing program.
But isn't that the purpose of contact tracing? Isn't that the gravamen of contact tracing is you tell the people who are affected so they can take appropriate steps to protect those people. Now, that being said, it's it's sort of like a bank shot. Had the district told Mr. BOUTAUGH would have taken appropriate steps that would have avoided infection to Mrs. BOUTAUGH and then avoiding in utero transmission to
Sure, but the
child.
defendant is the district, so that brings up the public duty doctrine. I mean, so now we are outside of the district's concession with respect to a special relationship through Ms. BOUTAUGH, and now.
But I don't know that we are, because the only, as counsel said, it's a matter of biology. So the child is going to be infected by way of the mother, and then.
Sure, but then Ms. BOUTAUGH could have been going back to my question before, could have been anything other than a police officer.
But the fact remains, one, that she is a police officer, and two, this is MPD's contact tracing. This isn't general DC contact tracing. This is MPD's contact tracing that didn't inform Mr. BOUTAUGH so appropriate steps could be taken. So it is taken, it is within the concession because you do have that relationship with the district, with MPD.
Run that by me one more time. I'm having trouble. It seems like you've got a chain going this way and there's 3 links in it, and somehow you've connected link 1 to link 3.
I think ultimately you do end up linking 1 to 3 because that's how you ultimately prevail in this case.
But 2 is the necessary link, and it's the biology of 2.
Correct.
2's employment there. I mean, I just don't see where it's in the same concession.
Yeah, I guess it's the issue is that you've got sort of, I think it's almost been conceded at this point that a partial remand is called for here on the workplace claims. But I think in with regard to the contact tracing claim, you've got Mr. BOUTAUGH, well, you've got the district over here, and the district needs to inform Mr. BOUTAUGH of and have a good contact tracing program that does what it's supposed to do. So it's got to go from here to here. And then it's got to go once, if they do that, then Mr. BOUTAUGH will take appropriate steps to avoid transmission to Mrs. BOUTAUGH and ultimately infection to the minor child. I don't see where on a 12B6 that's subject to a heightened pleading requirement to allege that duty, because we're doing it in a sequential way where we're saying they need to have a valid contact tracing program, a contact tracing program that is achieves its goals.
You keep calling it a heightened pleading requirement, but isn't it really just that your pleading requirement got easier because of the concession on one thing?
I wouldn't necessarily look at it that way, but I think it's the reality of the situation is that they're both police officers, and 2, that there is that special relationship there, and it is as counsel said, the biology of it as well. There's no getting around the fact.
Sorry, can you unpack that? If we're talking about the contact tracing,
Right.
what special relationship are you relying on?
I think it's ultimately the special relationship. I think it's ultimately the same special relationship. It just arrives by a different way.
Which special relationship?
Well, the special relationship between the child by way of the mother through Mr. BOUTAUGH. I mean, it is convoluted by necessity.
But
because-
I'm sorry, I sound like a broken record, but are you saying that special relationship would exist if Ms. BOUTAUGH had been an attorney or an accountant at home? I mean,
Correct, because I think if you have the special relationship at one level, you essentially have the special relationship at all levels. But in
I
this
don't-
instance,
what do you
they're
mean
both
levels?
MPD officers.
So then is that a special relationship for every other member of the family residing in the household? Like, it seems like.
or a roommate?
I think the nature of this case of the pregnancy makes it, and the in utero transmission, that there is no way for those people to take any actions. I think that makes it much more direct and impactful.
I mean, but the premise, I mean, that doesn't make sense to me, because if the link is a duty owed to Miss BOUTAUGH through Mr. BOUTAUGH, then it should be everyone Mr. BOUTAUGH has contact with at home from there. You know, if he doesn't know so that he can separate himself out and keep his family safe, then every child in that house is at risk. And every member of the family in that house is at risk. And that kind of eviscerates the limitations on this public duty doctrine, doesn't it?
I don't think it does. Well, for a couple reasons, I don't think it does. I mean, because it is limited to that house, that family. We're not talking about general public or anything above and beyond there. And I do think that there is that special relationship. But I think that this is also a situation where discovery is going to bear this out. Expert witnesses are going to bear this out. And if it doesn't come to pass at that stage, then it'll be ended and that will be that. But to say that this was somehow at issue before, it clearly was not.
I mean, it
because-
seems to me that your argument would have to almost be that you would not have to present any experts because you've pled both means of transmission and you don't have the public duty doctrine entering the situation either way. So you can go to trial and say, doesn't matter where or how Ms. BOUTAUGH contracted COVID at that point, right? Whether she contracted it at the workplace or through her husband.
Interesting thought. It's I'm kind of thinking past the sale because I'm focused on the issue here today, but that very well may be the case.
I mean, it is kind of relevant to us because it seems, well, I don't know, gotten myself confused, but that doesn't seem right to me
It is confusing
as a
and
theory of the case.
yeah, I mean, I'm certainly looking at it kind of more as counsel was saying that this is going to be a long, hard fight on remand because we are going to have to get experts and we are going to have to prove what's more likely than not. And we're probably going to have to show the more likely than not vector of transmission and then work backwards to the breaches, whether it's the contact tracing, whether it's the workplace exposure and work backwards from there. So for me, I'm certainly viewing this as an expert case. But if there's a way that that's not an expert case, then
I'm
we'll
not
take that
telling
as
you
it
how to
comes.
litigate this case if you go back to the trial court. I'm just telling you that the logical extension of your argument seems to be that it doesn't end up mattering how she got COVID. And that doesn't seem to line up with our analysis of the public duty doctrine.
Yeah, it's possible, but I'm not sure about that. No other questions? I'll stand down.
Thank you, counsel, for
Thank
your
you.
argument. Thank you, Ms. Johnson. The case will be submitted.